or after next week. Item number 43, my lord.
43.
Yes, my lord.
Counsel for petitioner and consent of the respondent.
Highly obliged, my lord.
Yeah, please, your lordship. With the consent of the respondents, I beg to mention item number 45, lordship. It can be kindly taken up next week.
With same order, give the date.
Much obliged.
Right, please, Your Lordship. My lords, I beg to mention item number 9. There's another matter pertaining to the same FIR that has been listed tomorrow, my lords. Both the matters may be tagged and listed tomorrow.
9 list the matter along with
BA 3750 of 25.
on 28.
28, my lord. Obliged.
Please, Your Lordship. Lordship, I beg to mention item number 32 of the daily list. Lordship, kindly pass over the matter for the day as my senior Mr. AAR Karim has some personal difficulty.
We have not received the case diary.
We did not receive list again on
Lordship, interim order may continue.
interim order passed earlier to continue.
Last January 1st day. Now you Dhubri.
Obliged.
Your Lordship, I beg to mention item number 56 of the supplementary list. Your Lordship, with the consent of the other side, we would like to adjourn the matter for today and fix it.
Date may be fixed.
Yes, sir.
I am the respondent in this matter.
Yes, give a date. Same order.
If next week is possible.
Listen.
8.
Possibly, sure.
For motion is BA, item 1.
Lordship. Lordship matters leading to NDBS, my lord, commercial quantity, my lord.
All right, CD.
Call for the case diary, my lord.
Yes.
December.
Here, POXO is involved, my lord. So, my lord, notice may go to the OP number 2 and city may be called for. Short date may be given, my lord.
Notice to respondent number 2.
1612.
12. Obliged.
Happy Lordship. This is my lord second bail application. Earlier was rejected by the final report. That is page 19. And petitioner behind the bar for 95 days, my lord. And when it was rejected during the relevant time, it was 71 days. So up to that call, CD call. It's initially it was an attempt to murder, but subsequently it become
95 days.
95 days.
Then mandatory
charge
period
sheet-
is over already. And we
Has
have to
charge
take-
sheet been submitted?
we have to take inspection whether charge sheet file or not.
That is after me.
When can you get?
Tomorrow,
You can get today also.
they also.
If it today, we'll take up later.
Bless.
Maple Lordship. Regular bail application, road accident case, Lordship. My lord, page 14 is the FIR, Lordships. This is a driver, 56-year-old driver, truck driver, Lordships. Oh, he's behind the bar for last 24 days. On any condition, my lord, he may be allowed to go on bail. It is a road accident case, my lord.
CD.
I'll give a short that, Lordship. The Jimma also granted, Lordship.
Yes, yes. You hit and ran.
Hit and run. 10-12. Can you go sort that, Lordship?
Item 5.
No, you deserve to be in.
Here in this case regarding similar incident, Lordship already perused the FIR and granted bail, Lordship, that in the present case FIR, your Lordship will find page 13. That regarding that misappropriation in the scheme of Janani Suraksha Yojana, Lordship, that in 25 also your Lordship granted bail to the same person. And regarding same incident, 3 FIRs were lodged, Lordship. In first case, he was granted interim bail by this honorable court. He appeared before the investigating officer and subsequently he was arrested in another case where your Lordship granted bail. This order, copy of that order I have given to your Lordship. And thereafter he was shown as in the present case, Lordship.
What is the allegation in the present case?
Same allegation, Lordship, that misappropriation is committed in the scheme of Janani Suraksha Yojana. That page 13 is the FIR. This is lodged by the Superintendent, Civil Hospital, Morigaon, Lordship. Earlier was lodged by Superintendent of Police, Lordship. That I have enclosed that FIR also, Lordship will find at page 20. That FIR was lodged in connection with a letter of Lordship, Additional District Commissioner, that is page 21. And the first FIR where Lordship that he was granted interim bail, that your Lordship will find page 22. That is also of similar allegation, Lordship. That allegation
Present
was,
affair is page 21.
Present is 13, I think.
present is 13, page 13,
And that's
1-3.
Superintendent of Morigaon Civil Hospital. The allegation he stated the privileges from the getting benefit from Janani Suraksha Yojana.
That is the allegation in other 2 cases also, the allegation.
Here allegations, sir, JSY payment documents are also missing.
Allegations are similar in nature regarding that Janani Suraksha Yojana, and the subsequent development is also there, Lordship, that after filing of the case, I came to know that, Lordship, one of the co-accused is granted bail by the trial court below, Lordship, on the ground that charge sheet is submitted. So, Lordship, may kindly have a look at that order also, Lordship, after filing of this case. In the present case where I am seeking bail, that in that case, Lordship, and considering that aspect, Lordship, he was granted bail and the length of it.
17.
Already in other 2 cases, Lordship, he is on bail, Lordship, and the present case is fixed on 3/12/2025 for appearance, Lordship. He will appear before the court and face the trial, Lordship, if anything is there. Otherwise, allegations are similar in nature, Lordship.
Charge sheet has been submitted in the case.
That is the Lordship order reflects, Lordship. And I have seen, Lordship, that E-code details, and E-code details said on 19/11/2025, the charge sheet was put up and thereafter the case is fixed on 3/12/25. That copy also I have given to your
In this
Lordship.
case.
E-court details I have given you.
Co-accused has been granted bail.
E-court details, Lordship, that charge sheet was submitted, first hearing on charge sheet that 19/11/25. Next date is on 3/12/2024.
I heard learned counsel for the petitioner and application under, so petitioner has been shown arrested in this case. On, when were you shown arrested?
7/10/2025. Page 16 is the order.
Earlier, he was arrested in connect. Oregon PS case number 254 of 25. Where he was granted bail by this court by order dated 25/11/2025. In bail application number 3697 of 25. Thereafter, he was shown arrested in the present case. Here's effects of the case are that this 11/25 lower court. Yes. Third paragraph. Appears from the order dated 12/11/25. Bail application number 532 of 25 passed by the learned session judge Morigaon, granting bail to the co-accused that the charge sheet has already been submitted. And keeping in view the same, the further detention of the co-accused was to be necessary. Granted bail. In regard to the above and clarity in mind, the president has to be released on bail. Once you
Obliged, Lordship.
Item 6.
This is the Lordship. For it is the application, and in this matter, charge sheet has also been laid, my lord. It's a matter, the matter pertains to my lord offense under special act. At this stage, my humble prayer is to call for the trial court records, my lord.
Partial quantity, trial court records.
And my lord, another prayer,
call
Lordship.
for the TCR along with the CD. Please
Lordship,
come.
another prayer to call for a records of PRC number 1531 or 25 pending in CGM Sribhumi. Along with this record, my lord, it has a bearing, my lord, since we have raised a plea of.
Let's give the number.
Yes, my lord.
Call for the TCR along with also call for the TCR of
TCR of my lord, PRC number 1531/25, my lord. I'll give the number, my lord, both the cases. What date may be possible, Lordship?
Receive 17, 16, 17, 12.
Can it be possible 16? Deep double.
May I please, your Lordship? Regular bail application, Lordship. FIR will find Lordship, page number 16, Lordship. And there are two FIR, Lordship, and one FIR is lodged by us, Lordship, and another FIR lodged by the informal, Lordship. And some scuffle is there between the parties, Lordship, and FIR will 16 operating person, Lordship, page number 17, Lordship. May I
all right CD.
Well, my one submission, Lordship, the petitioner number was 70 years old person, Lordship.
Whatever.
He has no any role at all, Lordship. 10, 11, or 10, 12.
10, 12.
Not funded bill. Now can little short, Lordship, 70 years person, Lordship.
512.
Lordship, deeply obliged. May I please, your Lord, 483 application, my lord.
But I take your lordship the FIR. I am 135 days behind the bar. In a case of 302, my lord. I take your lordship page 13. My name is not in the FIR. But in the forwarding report, the IO has mentioned that 5-6 days ago, there was a quarrel between the deceased and this accused person, for which they suspect that I am involved in this. Where actually informant husband went to fishing when the night 9:30. And my lord, next morning he did not return and found dead with facial injuries in his person. And my lord, and the mobile location
name?
was also found.
Abdul Momin.
Yes.
Who are you?
I am the purely on suspicion. I was taken into custody, my lord, 135 days behind the bar. Case has been charge sheeted, my lord. But charge sheet also, my lord, the medical report, you will be surprised to know, my lord, it is mentioned that cause of the death could not be ascertained. I take your lordship, page 34. Page 34, my lord, kindly come to this side for the opinion regarding the cause of the death is kept pending till the report of chemical analysis comes. So they could not ascertain. Then, my lord, there is another chemical report that page 36 that is given by the Toxicology Department of the Government of Assam, that no poison was detected in the exhibit such and such toxin. So now how he died of not poisoning, and this report is still awaiting. 36 days behind the bar. Trial has charge has been framed without consideration, and next day is fixed for the production and case management hearing, my lord. That was done on 20th of 11, but it was not done on that day I had. It has been passed over. So, my lord, I am to arrange my defense. Kindly give me, I pray for his bail, my lord, under any condition, my lord. I will regularly appear into the court, my lord.
How can we grant bail without knowing anything?
A cautionary call for suspected charges of crime already.
My lord, 135 days, my lord, your lordship will appreciate that behind the bar, my lord. And my lord, the medical evidence, you see, that is, they could not ascertain the cause of the death. In the FIR, my name is not there. On the IO has forwarded that my mobile was found under that same tower location. It is very remote suspicion, my lord. It's very difficult to entangle him in the conviction, my lord.
Where is
But-
the charge sheet? Is there?
Charge sheet is there. That also I will show you, my lord, kindly.
Yes, 13. Yes, 13.
Human collect. Page 23, my lord. Charge sheet, kindly. Peruse, my lord. During investigation, previous IO visited the recorded a statement of the witnesses, exclusively magistrate had done inquest over the dead body. It will do. PM report deceased was collected from the civil hospital. Sribhumi blood sample of the deceased sent to the FSL Kahilipara. Viscera of the deceased person was sent to the RFSL Silchar, and viscera report of the RFSL Silchar arrest and forwarded is one accused Abdul Munin. This is myself, my lord. We have personal report and as well as Silchar Kachar. Exhibit A, B, and S. Therefore, the prima facie case is established, my lord. How it is prima facie case, my lord? PNS against the accused person of Abdul Mutin, considering the facts and circumstances of the praise under section 103 has been well established. How remote the idea, my lord, that is well established.
Anyway, court has found prima facie material and frame charge. We do not know anything else now.
Well, what is the material before the court? That is to be also considered, my
We
lord.
don't know. We want to see.
Purely, my lord, purely the IO has written and
That is what we want to see. What is there? When the court has framed the charge, we will assume that there is prima facie material. That is to be examined then.
That-
When can you get it? Yes, PP. When?
Your lordship can consider the bail, my lord, after charge sheet also. There are the series of judgments of our own High Court and Appellate Court.
We are not disputing that.
Yes.
From registry of 1612.
Okay.
Sribhumi from Sribhumi.
Yes, Sribhumi, no doubt.
আমি তো নিটো ৰেষ্টি আহিব পাৰোঁ 16
It will anyway come by in electronic mode, isn't it? Whether it is Sribhumi, whether it is Kamrup, what does it matter? Have it at an early date? When?
10, 12 will too long, my lord. Today is the 27th.
You have
I
waited
pay
for,
on 8th, my lord, 8.
Sir Biswas, you have waited for 135 days. Now don't start haggling.
Anyway, let it come on 10th, my lord, I have got it.
Ten copy of TCR.
Please, your lordship. Case 14 is a FIR, my lord. It is a missing case, my lord. The victim has been recovered. He has been arrested on 8 November 2025, my lord.
Pokso is there, so first issue notice.
No, not a POCSO case, my lord. Section 87 BNS case, section 87 and section 137 subsection 2, my lord, kidnapping.
Because patan hai, because patan hai.
I don't deal Islam.
Pokso nice.
40 teenagers, my lord. The petitioner is only 19 years, my lord. 14 is the FIR, my lord, in vernacular form. The missing case, my lord. The victim family as well as the petitioner's family well known to each other. Same village, my lord, both the parties.
Sir, it's a minor girl.
Yes, but.
Okay, CD.
This.
You did. CD.
11, 12.
Apologies.
Please, your lordship. So the petitioners were picked up by the police, my lord, on 18/10/2025. Allegation was that, my lord, they were involved in cheating some people while they were using their ATM cards. Now, what happened, my lord, from 18 to 20, for 2 days, they did not produce the petitioners before the magistrate, the police. For 2 days, they tortured the petitioners. All of this is on record, my lord. After 2 days, they produced the petitioners before the magistrate. The magistrate sees their conditions, records their statement, and refers the matter to the State Police Accountability Commission and the Human Rights Commission to initiate proceeding against the policeman. Your lordship will first kindly come to the FIR at page 12, madam. Page 12, madam. Your lordship will notice, with reference to the subject cited above, I have the honor to inform you that on receipt of reliable source information at about 8 p.m. on 18/10/2025, it came to light that certain miscreants were indulging in fraudulent activities by deceitfully replacing ATM cards of unsuspecting citizens at ATM booths without their knowledge. The source further reported that the said persons were moving about in the Borghat area and were using such fraudulently obtained ATM cards for wrongful personal gain. Accordingly, a GD entry was made by so-and-so, and the OC of Nagaon Police Station was duly informed.
All right, what had happened earlier, magistrate has taken care of. Now
Well,
we are on the.
magistrate has only referred the IO to the police. That does not, my lord, the humiliation which I have suffered, the torture which I have suffered, my lord, that does not go away, my lord.
Yeah,
Now
that
we are
does
in
not go
custody.
away, but we are here on the question of bail now.
Your lordship will kindly consider that we have already been in custody. If your lordship goes by 18/10 for 41 days. These are offences, my lord, of cheating and extortion. Extortion anyway would not come. 60-day offences, my lord. Once we have been tortured, my lord, the state cannot keep on punishing me, my lord. 40 days already in custody, my lord. So I am humbly praying, my lord. If your lordship is inclined to examine the case diary, may I pray, my lord, at least interim bail may be considered, my lord. Your lordship will see the way they have acted, my lord. The FIR evidently is clear that on 18/10 they were picked up. The grounds of the arrest, my lord, page 22, your lordship will see they've shown it as on 2010. We may be criminals, my lord. The state cannot also act like a criminal, my lord. Magistrate
Where from do we get that when they were picked up and when they
My lord,
were just
page 13, the FIR, your lordship will see at 9:15 p.m., my lord, 18, the petitioners, they were picked up, my lord. Now, The FIR was lodged on 1810 after picking them up. Now page 22 onwards, my lord, the notices, my lord. Date of arrest, my lord, 2010. Page 22. And 25, no, everywhere, my lord. And then page 38 is the magistrate's order, my lord. And relevant portion, your lordship will find at page 39. And last part, my lord.
When a sorted lordship will provide what is the case there. If a case there, lordship will consider a player lordship.
The case there will also, my lord, when the police have gone to this extent, my lord, there is no doubt that the case there will also be full of implicating materials, my lord.
When were they produced?
Produced on 20th, 38 at 4 p.m., my lord. Page 38.
When could they have produced? They were picked up at night.
18th
So the
18th
24 hours expired at night.
19. But my lord, they showed the malice which I'm pointing out, my lord, is they showed their arrest on 20th. They picked up on 18th, they showed on 28th. And if your lordship will also examine this part, that they were tortured. Had there been no torture, then perhaps there could have been some explanation as to why there was delay. But the very fact that there was evident torture, my lord, that shows the malice, my lord. Why they were kept there for 2 days, my lord. Their job is to investigate, not to torture people, my lord.
Where is the magistrate's order?
Magistrate's order, my lord, page 38 and relevant portion, page 39 starts from the last line, my lord.
Honest, Tripod has already observed and referred to the State Police Accountability Commission. Lordship.
This is the subsequent bail application. Page 47.
47 is the first bail
Production
application.
date is what?
Yes, my lord.
That order is at place, which place?
Production date order, my lord, page 38.
38.
38.
Twenty 25.
So that part is over. Magistrate has taken action.
Yes.
That does not itself entitle you to bail in case you are, if otherwise you do not deserve bail. Subsequently, also the magistrate, your bail application was rejected on 17/11/25.
My submission is that there are two aspects, my lord. One is, my lord, violation of Article 22 in the sense that I was not produced within 24 hours of being detained by the police. Secondly, my lord, the whole conduct of the police, my lord. From my detention till my production, the period which they kept us, my lord, detained, during which I was subjected to torture. The magistrate takes care of it. This is statutory duty, my lord. He sees a case of production, custodial torture, he refers the matter, my lord. But the violation of my rights, my lord, my human rights, my fundamental rights remain, my lord. And now I am in custody, we are in custody for 41 days, my lord. These are 60-day offenses, my lord. So they have, whatever they could do or they had to do, they have done, my lord, including certain things which they are not supposed to do. Now, because on our complaint, this case has gone to the SPAC and the human rights, my lord. Now the police is further against us, my lord. So considering that length of detention and all of these aspects, my lord, may I pray for faith? Initially, they registered the case under 111, my lord, organized crime, because that bypasses the necessity of issuing a notice under 36(3). After my arrest, after my detention, then they come up and say, oh, we inadvertently registered the case under 111. It ought to have been under 112. So let us modify this. That order is at page 43. So then again the punishment comes down, my lord. Now it becomes a case of 112, organized petty crime. So from the very registration of the FIR, my lord, till now, my lord, every stage, my lord, the police has done something or the other. Otherwise, we could have pleaded that this was a case which would be covered by Anish Kumar.
It appears they could have produced on the next day before the duty magistrate.
Yes.
Within 24 hours. Prima facie, there is violation of Article 22. But when counsel for the petitioner. Additional PP. We only allow interim at the moment. We want to application under strength. Call for the CD. Para it appears that the petitioner were arrested on
10/2025.
18/10/2025 at 9:15 PM. But they were not produced in 24 hours before the magistrate. It was only on 20/10/25 that they were produced by the magistrate. Therefore, prima facie there appears to be a violation of Article Constitution of India. Having regard to the above, directed that the petitioners be released on interim bail of ₹1,000 each with 1 CRT or like amount.
TGM no hoga,
Again,
deeply obliged, man.
My lord, it is a property dispute between the mother and the son. I am the son, my lord, and have been in jail since 77 days. For a moment, kindly see, my lord, page 3, para 4. Para 4 and 5, my lord.
He's still alive.
No, my lord, it's a simple injury. Page 19, kindly see. This is the medico legal case report. I have annexed the certified copy, my lord. A simple injury, my lord. Nature of injury is simple.
Age?
Page 19, my lord. Medical legal case report. Prepared by Dr. Saurabh Das.
Is this Jeevan Jyoti Institute of Medical Sciences?
Nature of injury is simple, my lord.
Multiple blow over scalp.
Alleged no assault, simple. Nature of injury is simple, my lord. My lord, my mother and I have a wife and a 3 years child also. And matter is all later, my lord, settled, my lord. And due to my detention, the whole family is in, my lord, facing severe starvation now. Because I am the only person, my lord, only male member. And it is the property dispute, it is mentioned in the FIR also.
It has been submitted under
Submitted,
what
ma'am.
section?
Charge is submitted.
What section?
Charge is submitted, my lord, section
1172 and 109.
is
Attempt
109 is not there, my lord. Injury is simple, my lord.
The charge sheet also, it is accepted that the injuries are simple.
77 days.
Third learned counsel for the petitioner, had learned an additional PP. An application under so and so. The allegation against the petitioner, comma, who is the son of the government, comma, on account of a property dispute, had assaulted the informant with a bamboo on the head with a bamboo stick. But local persons appeared on the spot and rescued the informant, who was thereafter taken to hospital for treatment. The charge sheet has already been submitted. It appears from the medical report as reflected in the charge sheet as well that the care of the injuries were simple. Having regard to the above as well as the that the petitioner has been behind bars for 77 days. Further detention of the petitioner is not considered. Bail is allowed. 50,000 1COT. Here regularly in the trial, one comments.
My pleasure, Lordship. Lord sir, case Lordship, the police visited my house, searching me, Lordship. And for his Lordship,
Yes, instruction.
it has been registered against the petitioner, Lordship. White PS on PS case number 321/25 under section 87(3) subsection 5 and read section 6 of POXO Act, Lordship.
You must have the seat. POXO is also there.
Notice should be going case and corporate is this.
Learned additional PP on instructions received submit that FIR has been registered against the present petitioner as case number,
Case number 321/25.
which PS?
PS case, Soigaon PS case number.
Soigaon PS case number
321 under section 87 3 87 3 section 5 and read of section 6 of POCSO.
and call for the CD also. You made a respondent.
No, Lordship,
Not included, but because
well, I may be allowed to withdraw, Lordship, and in the meantime, Lordship, and I.
You will file fresh, okay.
Fresh, Lordship.
You are allowed to withdraw and there is no in the meantime.
Not to take coercive in the meantime, Lordship, until filing this, Lordship.
CD also cut it, yeah. And it counsel for the case. For the same case, present case, in order to enable him to file appropriate application. There is allowed cases. Is withdrawn.
Obliged, Lordship, obliged.
Well, this case in a counter blast case, Lordship. My lord, the petitioner's charge sheet was submitted against the petitioner, Lordship. And in that case, my lord, someone was issued, Lordship, by the learned trial court, Lordship. My lord, the petitioner engaged counsel, Lordship. Counsel submitted applications for, my lord, timed, Lordship. Those times were, my lord, granted, Lordship. In a date, my lord, the petitioner, he was out of Assam, Lordship. For working purpose, he went there. Lord, submitted without step, my lord, he was absent, Lordship, and non-bailable warrant was issued, Lordship. And thereafter, his, my lord, his counsel regularly submitted applications, Lord, those were rejected, Lordship. Ultimately, when another date, Lordship, non-bailable warrant has been issued, Lordship. Now he wants to appear, Lordship, defend the case by appearing in the trial court, Lordship. So he may be granted bail, Lordship.
charge sheet under section
Sessions tribal case, my lord, CGM cannot grant him my lord, bail.
457, 377, 325, 11, 376 there also.
My lord, the informant's husband, Lordship, he was convicted 2 times, he was convicted, Lordship, he committed theft at my home, Lordship. And then FIR was lost, my lord, he was sent to jail, Lordship. Thereafter coming from, my lord, jail, Lordship, he, my lord, made out a false story with her wife, Lordship, attempted to rape, Lordship. My lord, that is, my lord, only.
Your earlier previous bail application was rejected.
My lord, by learned sessions, it was rejected, Lordship.
Record may be called for this.
You did not appear for 4 years and now you, after charge sheet is filed, now you want to escape.
Learned counsel when submitted applications, Lordship, I was out.
Charge sheet for learned counsel for the petitioner, charge sheet has already been submitted in the case, hence call for the TCR along with the CD.
Obliged.
Lordship, may I kindly see allegation at page 9, Lordship. Allegation of theft of railway materials, Lordship. Full fact of the case is that I engaged one person in my shop. I have multiple business, Lordship. I engaged one person in my shop to look into the affairs of the shop and maintain the same. And he has also admitted, Lordship, he is arrested and the material value amount to rupees 7,200 he received from some vendor, Lordship. Lordship, may kindly see page 15. He has admitted everything. Page 15, Lordship.
Petitioner is the owner of the that Gudan.
Yes.
And he is the owner of the Gudan running by someone.
Yes.
That person stated that on the in consent of the owner Abbas Ali, he has received the railway material.
That is just to save himself, Lordship.
But
To save his income.
he is saving himself now. This
Hey.
petitioner is saying that he has taken, well, some persons is doing, well, helping the, because of this cycle is going on. Railway materials has, well, theft and sold it to some scrap. And because some person buy it, because of that, the cycle, whole cycle is going on and railway materials are, well, this theft.
All
is
right,
going on.
CD.
I am
He has
notice,
implicated you.
Lordship, notice
How
under,
can you grant?
Lordship, notice under 35(3) is sent to me. I am ready to cooperate, Lordship. I may be protect, Lordship. I will appear. Notice I have annexed, Lordship. Page 14
You
is the,
appear, and if the IO feels the need to arrest you, he will arrest you.
Lordship, I am seeking protection, Lordship.
You are
I
seeking
am not
protection,
involved.
so
The
we have to
person-
examine.
The person who is involved, he has.
Prima facie, you are implicated, so we can't grant
he
you the
has- he
privilege
has
of free arrest
admitted
bail unless the
that-
CD says otherwise.
That I have engaged him to look into the affair of the shop, Lordship.
Eight
And
to-
the, one second, and the, and
Alright.
as he has stated that he has consent, this is only to save his skin, Lordship. I will be protected, Lordship.
I am as a CGC, Central Government Council. This is railway matter. I am SCGC, KK Parasar SCGC.
Anticipatory bail in a POXO matter. Notice
Call for the CD, issue notice to the respondent number 2. Steps by registered post with AD within 3 days.
1812.
May I please, your Lordship?
Mm.
Lordship, it is a pre-arrest bail application, Lordship. Lordship, the petitioner is a lady, Lordship, and Lordship will find the FIR on page 13, Lordship. May I read the FIR, Lordship?
That is page 8.
Lordship. Page 13, Lordship.
Your name is Sobita Pathak.
Sobita Pathak. Lordship, why I am apprehending arrest is that, Lordship, my husband has been already been arrested in this case, and he has been working in a company, and there are allegations upon him that he has misappropriated certain funds which are supposed to be transferred to the employees, and upon doing so, he has also transferred some fund to his father's account, to the petition, to the father's account, and to the account of the present petitioner, who is his wife, the one who has been arrested in this case. This is the only allegation in the FIR, Lordship. Otherwise, the petitioner is a housewife, Lordship, and
Yes, transferred some amounts to her account also.
my name is there in the last second para on page 13, Lordship.
Yes, your
Page
account.
14. On my account also, Lordship. With all due respect, Lordship, my passbooks and everything were there in the possession of my husband, Lordship, the petitioner husband. I have no knowledge about the same, Lordship.
Alright, hard
And I have
counsel for the petitioner, additional an application under so and so. The allegations as reflected in the FIR pertain to diversion of funds of the informant company, which were to be deposited in the salary accounts of the employees of the company maintained in the State Bank of India. It is alleged that the husband of the petitioner, who is a junior accountant in the informant company, has, by manipulating the records, diverted the salaries of other employees into his own account, and subsequently diverted them to the account of his father, as well as that of his wife, that is the petitioner. It is submitted on behalf of the is a housewife. Her bank passbook and all other documents are under the control of her husband and knowledge regarding any deposit of funds her account. Call for the CD. Regard to the above submissions of learned counsel. Did that in the interim pre-arrest bail of rupees security for like a arresting connection with the FSA. 7 days before the IO. Cooperate with the investigation. List again on.
Deeply obliged, sir.
What was called for regarding the any cases?
Yes, report will be required, Lordship, in this.
So report, we have not received the report, Lordship. Sir, we think the matter on 2nd of December, we'll try to produce the report, Lordship.
Lordship, until then, no.
What is to be produced?
Lordship, whether any complaint or FIR has been lodged against the
petitioner.
present petitioner, Lordship.
It is from Lanka, Huzai.
Does it take so long?
We have not received any instruction regarding that, Lordship.
I got on Monday.
Lordship, until then, no.
Instructions not received. Is the matter on Monday?
Yes, sir, and
Deeply obliged.
Anticipatory bail application, my lord, FIR page 13. Before going to the FIR, my lord, I just place the fact of the case, my lord. There's a clash between two group of these two shore areas people regarding, my lord, dispute regarding a plot of land, my lord. So, my lord, one people of the one shore area attack another shore area, my lord. Now this FIR has been lodged, naming all the male members of the, my lord, that particular village, my lord. 28 persons, my lord, name, all the male members of that village. My name also included and my family, other members also included. I am a headmaster of a school, my lord. I am staying 40 kilometers away from the place of occurrence, my lord. And I am the single teacher school, I am the headmaster, my lord. So on that day, I was in school, my lord. So, my lord, my name is Bas because entire family name is there. There is no specific allegation against anyone. The below mentioned accused persons. Only that line, my lord. Your lordship kindly see page 13, my lord. Is the FIR. No specific allegation anyone, my lord. I am the CL number 5. CL number 6, 7, and 22 are my brothers, my lord. They are in the staying in that village, my lord. I am.
It is a death case, so we have to see the CD.
My lord, on that particular day, I was in school, my lord, and I have annexed the my lord, document also. And
What document is there?
Your lordship kindly see that, my lord, page 22, my lord. At 9:30, I am the single teacher school, my lord. There is a meeting in that point of at 9:30, I was schooling. And I am the headmaster, my lord. If I am LST school, it will be closed, my lord. And that is, my lord, I made a statement that is 40 kilometers away from this school. And I am living there. I am not in my village, my lord. My ancestral village, my lord.
It took place on 6:30 AM.
No, 6:30 AM, 8 AM. 8 AM. They started
8 AM.
8 AM. So that's why, my lord, if any found anything, my lord, they'll maybe, because I am not paying for, I remember others, my lord. The other 27, already 2 people, probably some persons have been arrested, my lord. Only, my lord, if any material, my lord, bail may be cancelled, my lord.
Mr. allegations as contained in the FIR. Paragraph 4, okay. Call for the CD. That the petitioner is the headmaster of a single teacher school, and on the day of occurrence, he was heading over a meeting held in the school premises. In this regard, the resolution of the meeting happened. Next. To the sense of the FIR. Specific against the present appears. And it also submitted that all the male members of the judge have been made accused in the FIR. Some of whom have all fact that the arrest of teacher, headmaster of the single teacher school, the functioning of the school. I did interim. Is done interim bail of rupees 50. Arresting authority in petitioner shall appear before the IO within a period. Matter.
Item 18.
My lord, FIR is at page 11, my lord. All sections attributed are against the person who is assistant branch manager, my lord. He is specifically named in the FIR, my lord. May I just read it, my lord? Lordship may have found, my lord. With due respect, I'd like to state that I am working as in charge. The TP so-and-so of United Insurance Company Limited, Guwahati Regional Office. Yesterday, it was brought to my notice that somebody has forged my signature in our claims approval note in settling National Lok Adalat MSCT Kamrup 1. I have sufficient ground to suspect that Mr. Abhishek Bhattacharya, AM, working in the same department, has a hand in this particular matter. Now, my lord, the allegation is regarding that claims approval note. It can only be prepared by the Assistant Branch Manager Abhishek Bhattacharya. Thereafter, it is to be placed before the first informant, my lord. This is the case, my lord. And my role is, my lord, I was the investigator there. We have stated everything, my lord. Little bit longish, my lord. Page 5, para 8, and page 6, para 9, my lord. That may kindly be looked into, my lord.
Page?
Page 5, para 8, my lord. My lord, all allegations regarding criminality, my lord, using a false document and denied, it has to be against the assistant branch manager who is named, because he can only prepare it and place it before the person who has lost the affair, his immediate head, my lord. Claims approval note, my lord. Nobody else can, my lord. It is regarding forgery there. And I may be called as a witness, but anyway, my lord, policeman has visited my house. We have stated everything, para 8 and para 9, my lord. No criminality can be attributed to me. Possibly I was a witness, my lord. Because using a forged document as J9, that is bailable, but forging it, my lord, absolutely a non-bailable offense, my lord, and that is attributed to the
branch manager, my lord, and one panel advocate is also involved. His name also we have inserted, my lord. Again, I'm for the sake of repetition, repeating, my lord, that claims approval from forgery, nobody else can do it, my lord. Because it has to be signed by the person who is named in the FIR and thereafter send it to the first informant, my lord, who is his immediate superior, my lord. This is regarding dereliction of duty, my lord, but not criminality, my lord. Para 8 and 9, my lord.
Dereliction of duty may be intentional also.
Oh, maybe, my lord, but that would not, your lordship is correct, my lord. I agree, my lord, but that would not lead to that forgery part of it, my lord. That is the criminality involved. That I cannot do, my lord. Because that has to be done by the person who is named and thereafter send it to the immediate superior, my lord, who caught hold of it, my lord. Kindly protect me, my lord. If there are any material, any criminality, my lord, definitely the consequences will follow, my lord.
Mr. Mahajan, Learned Counsel for this petition. If this is an application under so and so. Para 2 of bail petition. Call for the CD. Having regard to the fact that the present petitioner is not an FIR named accused, and also considering the submit Learned Counsel for the petitioner that it is only the manager, that is the FIR named accused, who can put up the note for approval before the branch manager. What
My lord,
informant
in charge, that first informant, my lord.
before the
In
informant.
Hindi, Prabandhak, my lord. What designation it is, my lord, difficult to ascertain, my lord.
Right, Prabandhak.
Prabandhak হইলে Hindi 12 number case.
What has he described himself as in the FIR?
In charge, my lord, in charge TP Hub, my lord. United India Insurance Company Limited. My lord, first 2 line of page 11.
Page 11, who is the line of it is provided in the interim that in the event of his arrest, the so shall be released on bail of rupees 50,000. One surety for like amount to the satisfaction of them. It is further provided. Appear before the IO in a period of 7 days from today.
Highly obliged, my lord. Obliged, my lord.
Please, your lordship. Clearest bail application, lordship. Lordship, the petitioner, lordship, under the elder brother, lordship, and the lost FIR, and subsequently, lordship, the informant lost the FIR, lordship. First, lordship, FIR against me, lordship, that is page number 10, lordship. And section 64 is here, lordship, but that is not come, lordship, that because, lordship, the attempted, as per the FIR, the content of the FIR is very clear, is attempted, lordship. But otherwise, lordship, the fact is different, lordship. And our FIR is, lordship, and first page number 10, lordship. Against me, lordship. Concocted history, lordship. And our FIR is, lordship. Informant FIR is page number, lordship, and 99, Fakirganj case number 99, lordship. And our FIR is 98, lordship. Our FIR is page number 16, lordship. And attempt to murder is the
Both are same date.
our FIR is 109, lordship, and section is there, attempt to murder, lordship. And but
Your
there
FIR at page 10 is dated 9/10/25.
lordship, same date, lordship.
Same date.
Same date, lordship. At first, our FIR is registered, and subsequently, lordship, informant FIR is registered. Well, it is attempted, lordship. Otherwise, there is some dispute is there between the informant party and the present petitioner, lordship, and there the adjacent house, lordship, and there is a small village road, lordship, and in this regard, lordship, there are some disputes going on, lordship. Yes, lordship, I may be protected, lordship, and I have been very severely beaten. 109 is there, lordship. That is the informant, lordship. Well, the informant party getting information, lordship, and I have lost the FIR, lordship, and subsequently they came to the police station and lost the FIR, lordship. May be protected, lordship. Whereas 364 will not come, lordship.
Third learned counsel for the petitioner. PP. This is an for the FIR. Paragraph 2. Call for the CD submitted on behalf. Present FIR is a contrast to the FIR lodged by the petitioner side against the government same day, that is 9/10/2021, which was registered prior to the registration of the FIR lodged by the performance of the present case. FIR lodged by the petitioner side is registered as Fakirganj PSNS case number 98 of 25, whereas the FIR lodged by present informant that is Fakirganj PS case number 99 2025, thereby indicating that the present FIR has been petitioner had lost his submits learned counsel. Having regard to the above, I did that interim 50,000 same appear before the IO. 7 days.
Deeply obliged, lordship. Obliged. Deeply obliged.
Kindly pass over the matter and maybe fix at 2 p.m.
May I please, Your Lordship? Lordship, I am the mother-in-law of the opposite party, madam. What has happened, madam? One DV case has been filed against me, madam. The crux is that, my lord, may directly come up to page 78, my lord. The dates are very relevant, my lord. My lord will see the Chaklong marriage was done on 12/5/25. My lord have got it just below in the middle of the part. Today, 12/5/2025.
Is this?
This is a marriage certificate which is done under the Chaklong marriage. Just to indicate to the court that the marriage was done on 12/5/25.
Yes.
My lord got it?
12/5.
12/5/25. Dates are relevant.
Who are you? You are Mrinmay Jyoti.
No, my lord. I am the mother-in-law of the petitioner, the opposite party, Jayashree Lahon. Now, my lord may come up to page 79, my lord.
In informant is Jigyasri Lahan.
My lord. My lord may come up to page 79. My lord got it?
Yes.
Page 79, my lord, this is the inner line permit given by state of Arunachal Pradesh, my lord. The date is 7/7/25, my lord. This is very relevant and valid up to 9/7/25, my lord. My lord, have got it? Subsequent, my lord, will see that first is Atanu Gohain. This is my son. Madhu Majuli Gohain, member 1. This is Manju Gohain, member 2. Next page, my lord. To page 80. Next is Kankan Gohain. Kankana Gohain. Next is Jigyasri Lahan. This is the applicant in the DV Act, my lord.
Yes.
Now, my lord, what had happened? These all people had gone to Arunachal Pradesh to roam around in the to visit Arunachal Pradesh. This is the permit, my lord. Now, what happened, my lord? Now, my lord, after coming from that Arunachal Pradesh, we were once again thinking that this girl has some psychiatric problem, my lord. So we asked the brother-in-law, would you please go and check it up? So what happened, my lord? They were reluctant to go. Now, my lord, may come up to page 43, my lord. So somehow we persuaded the brother-in-law that please provide us the documents that you showed to the medical. They were reluctant, but somehow we persuaded. Page 43, my lord. My lord may see, this is 24 July 25. Jigyasri Lahan. My lord have got it?
Yes.
So, my lord, the diagnosis is F3 and F20, which is schizophrenia. It is an acute disorder which cannot be treated, my lord. It is a medication. So, what is hearing voices, withdrawn things that people are talking about her, 3 months, and anger. Is before her marriage, she was suffering from schizophrenia. This is the diagnosis, madam. Now, what happened after coming to know about this? We filed an application for annulment of marriage. There were several reasons, my lord. Neither we had any physical relation with this lady, neither it was ever disclosed that she was suffering from schizophrenia. After receiving this notice, my lord, what she did? She filed a DV Act, my lord. DV Act is at page 44, my lord.
Yes, okay. After that,
So now what is in the DV Act, my lord? That on, my lord may come at page 45, my lord. What is the contents of the DV Act? That on 12/4/25, the applicant solemnized marriage. My lords have got it? Now let me come up to the last page. When I informed my husband and the other members of the house, the opposite wrongful acts of the father-in-law, the opposite party mentally and physically tortured me. On 27/6, the mother-in-law and the father-in-law and the opposite party abused me with various slang languages, and they called my mother-in-law and sent me with them and refused to keep me in the house. After 15 days in my mother's house, I again came back. My lord, may kindly see 27/6/25. She says she has left the house and for 25 days. My lord, may kindly see the inner line permit, my lord. Basically, she is suffering from schizophrenia just because we filed that application as a counterblast, she came up.
or you are here against the proceedings in the DV case.
My lord. No case is made out, my lord. Just because we filed.
Are DV cases regarded as criminal proceedings?
Yes, my lord. I thought this will come up from my lordship. The recent judgment, my lord. So this has already been taken care, my lord. Justice Okha and Justice Uzal Bhuiya's order, my lord. Para 39, my lord. Last para. May I read, my lord? To conclude the view taken by the.
Yes, I've read this.
My lord.
I've slipped my.
My lord, I was of the opinion that my lord will certainly ask me this question. my lord.
I will have to deal with the last two lines.
My lord, absolutely, my lord. So gross negligence, my lord, there is nothing on record, my lord. What she says the marriage was done in month of April, my lord. Then she says nothing on record, my lord, even prima facie. Now she says when she was, my lord, may come up to page 44, my lord. 45. On 27/6/25, the mother-in-law and father-in-law opposite party abused me with various slang and drove me out of the house. Whereas, my lord, they have gone to Arunachal thereafter, altogether. Nothing on record, my lord. Just an allegation that she have put having no basis. Nothing is there.
Third learned counsel for the petitioner. This is an application under section first title. Notice to the respondent number 2. In regard to the material produced by the petitioner. That till the next date of listing. DV case number
79 of
Miss DV 79 of 25 pending before the MFC Golaghat. Please again on.
Deeply ovulated.
For admission item.
Yes, my lord. The quashing away, my lord, proceeding, charge sheet, my lord. Day before yesterday, I filed an affidavit to bring in some record, some document, my lord. Can it be taken up next week for final disposal? The case, my lord, I refused to marry a girl. There's a love affair. Now they file a case under section 4.
I don't the prayer of learned senior counsel for the petitioner. Is the matter again on?
Next week, my lord. My lord.
Some affidavit is to be called for.
My lord.
Some affidavit is to be called for.
Day before yesterday, I have filed an affidavit to bring on some affidavit filed by the victim, my lord. And that filed by the affidavit, I have annexed in my petition, my affidavit, that they have to be called for, my lord. Filed by the petitioner.
Registry to place on record the affidavit filed by the petitioner.
On
or resto-
25th, yes.
On
25/11. Have you called? My lord.
21.
May I please, Lord. Lordship, by this criminal revision petition, I have challenged the order dated 29/2025. Annexer DA, the annexer 4, page number 18, my lord.
Some instruction was supposed to be here. Whether regarding the status of the confiscation proceedings in respect of the seized fertilizer vehicle if initiated. And also CD of Bosista PS case number 324. Anything is available?
No, only question is that, my lord, if the confiscation proceeding has been initiated, my lord, then, my lord, the question of Dhima will not arise, my lord.
And that is what is instruction is
But, my lord,
required,
that's what, my lord,
whether
that-
it is initiated.
That's what a last order, my lord. Lordship may kindly peruse, my lord, that page number, my lord, 18, my lord.
Yes.
In paragraph, my lord, seen the report wherein the IO has stated that the vehicle bearing number so and so were seized in connection with the incident case and the said vehicle bearing number so and so are required for further investigation of the case. The IO has also stated that a prayer has already been submitted before the Honorable District Magistrate for confiscation of the seized fertilizers along with the aforementioned vehicle under Section 6A of the Assistant Commodity Act 1955 in compliance with the confiscation proceeding. Per order memo number so and so dated so and so by the office of the District Agriculture Kamrup, the said fertilizers and the vehicle mentioned above has been confiscated at Jorabad Police Station Outpost. And Sri Shankar Dutta SDPO has been duly authorized to initiate further proceeding under section so and so of the Essential Commodities Act. Seems that my lord, proceeding has already been initiated, my lord.
My lord,
Because,
only,
if we receive notice from the competent authority, my lord, he will get chance to, my lord, file his reply.
Confiscation proceedings, from this order, it appears that the confiscation proceeding is also over.
Yes, my lord, that is
What is the instruction is required?
my lord,
Huh.
confiscation proceeding only for the, my lord, for fertilizer, my lord. Last,
Fertilizer along with the
last,
vehicle.
along with the vehicle, last part of the order, my lord, page number 19, there is mention, the says urea fertilizer are to be auctioned and interested party have been requested to visit the shortest site prior to submitting quotation to the auction committee. Since the fertilizer are presently stored within the seized vehicle themselves bearing so and so, and due to unavailability of alternative shortage space at Jorabad Outpost campus, the release of the said vehicle on Jimma at this stage is not feasible. Only, my lord, this vehicle is kept here in the campus of outpost of the Jorabad for keeping the fertilizer. There is no sufficient space for keep the fertilizer. They keep the fertilizer into the vehicle. So vehicle is
If
not.
if there is a confiscation order passed, where is the question of Jimma again now? Jimma after confiscation?
That cannot be my humble summary.
I fail to understand this order actually.
My lord, actually, this order reveals that the confiscation proceeding is drawing for fertilizer, my lord.
So this order has been passed, my lord, pursuant to a report submitted by the IO, my lord, which is at page number 20, my lord. After this report, my lord, this order has been passed, my lord.
My lord, the vehicle was seized on 13/6/2025, my lord. It is kept in the open sky in the campus of outpost of Jorabad, my lord. About 5 months, my lord. My lord, if this Zimma is not allowed, then this vehicle will be destroyed, my lord. And it is commercial vehicle, my lord.
It's not very clear whether vehicle. The fertilizer is stored within the vehicle, inside the vehicle.
Within the vehicle.
And proceeding has also been initiated, my lord, completed.
The last part of the order reveals that, my lord, only.
We will need to see it's not very clear whether the vehicle, any confiscation order has already been passed in respect of the vehicle.
But we have to call for a report, my lord. What is the present status then, my lord?
That was already called for.
Last occasion report was called for, my lord.
Following report as called for regarding status of the confiscation proceeding in respect of the seized vehicle stroke fertilizer. As called for by order dated 13/11/25 has not been received. CD of Bosista PS case number 324 of 25 has also not been received. Who will give the, who will provide the instruction?
That, no, we call for the instruction, my lord, from the concerned police station, my lord. They have also issued requisition, my lord.
Yes. Learned additional PP to ensure that the instructions as sought for are obtained by the next date fixed. Take up the matter.
My lord.
Is the matter again on?
For that may be fixed.
Yes, give a short, there is a vehicle is there out.
17, 18 months.
Item 22.
Less.
It is your lordship. Lordships, this criminal revision petition has been preferred against the order dated 7/11/2025 passed by the learned Elaka Magistrate, whereby my petition for Zimma has been rejected, lordship. The order is at page 27, lordship. Page 27 is the rejection order. Fact of the case. is
Yes,
that-
instruction.
But I have sought for some time, my lord.
Lordship,
And the concerned IO is on leave, my lord.
lordship, may I submit?
No, we are going by the last order.
Yes.
Some instruction was, if he has sought some time, let it come after a week.
In this case, lordship, police has been intentionally delaying their matter, lordship. The entire investigation
Instructions as sought for has not been received. Instructions oblique status report as sought for has not been received. The IO is directed to
That may be-
produce the same immediately, positively by the next date fixed.
that may be given.
Fixed again on, give.
Well,
Earlier can be.
well, sir, yeah, very well.
Yes, next.
Item 23 to 28.
What is this?
Back to lordship, my lord. My lord, I would like to argue on the item number 23. And my points of argument on the other matters are listed as item number 24, 25, 26, 27, and 28 would be the same, my lord. To be or not to be, that is the question, William Shakespeare. I'm also in a fix to be or what to say or what not to say before lordship. That is the core question. My lord, this is an application under section 528 of the BNSS 2023 for setting and quashing of the NICA case number 2/2025 registered under section 138 of the NI Act pending in the court of the learned CJM Sirang. Before going further, my lord, I just want to draw your lordship's kind attention to page 15. Page 15. That is the NI case, complaint case registered against me, my lord. And now, my lord, I just want to draw your lordship's kind attention to page 3. Page 21, part 3.
You're on item 23.
Yes, item 23, my lord. Page 21, part 3 now. I'm just reading out the relevant portion for lordship's kind convenience with lordship's kind permission. That the accused person being well acquainted to the complainant requested for the monetary help And accordingly, the complainant paid 10 lakhs to the accused person in cash. My goodness, my lord. In 2 installments, upon promising by the accused that he will return the same amount at the earliest. My lord, in the whole contents of this complaint case, the complainant has failed to elaborate what the legal enforceable debt is. Your lordship is very well aware of the Honorable Supreme Court's order and also the various high courts relating to the enforceable debt must be explained, my lord. In a recent judgment of the Manipur High Court, my lord, it has been significantly stated, my lord, in a significant ruling on the Negotiable Instrument Act 1881 has held that the statutory presumption that a check was issued for a debt or liability under Section 139 cannot be invoked. I emphasize, my lord, Section 139 cannot be invoked unless the complainant first establishes the existence of a legally recoverable debt, which is absent in the complaint petition. At the same time, my lord, I also like to draw your lordship's kind attention to Honorable Division Bench order of the Honorable Kerala High Court. Cash transactions above.
So you want to establish your case on the basis of press releases?
No, my lord. I will submit not press releases. I will submit at a relevant time, my lord. I will submit the citations before lordship. I just want to give the brief
Yes,
of this
continue.
for
Yes,
lordship
yes,
kind.
please continue.
And my lord, I just want to draw your lordship's attention to Kerala High Court's order. Cash transactions above 20,000 in violation of income tax section 269 SS, not legally enforceable debt under NI Act. I just want to draw, this is the book with the lordship's kind permission, my lord. I just want to read out the relevant portion of the Income Tax Act. Section 269 SS, mode of taking or accepting certain loans and deposit. No person shall, after the 30th day of June 1984, take or accept from any other person any loan or deposit otherwise than by an account pay check or account pay bankrupt if the amount is 20,000 rupees or more. So, my lord, here it is. He has deposited, the complainant has said that he has deposited 10 lakh in cash, which is in violation of the income tax law, my lord. And what is his standing, my lord? What does he? What he works? How much amount, huge amount he has got? And my lord, in this regard, I just want to, again, to take a lordship to Annex 1, page 36. Annex 1, page 36. The date entered in the check is 10/12/2024. 10/12/2024. I repeat. And my lord, in this regard, I filed an e-complaint, which is on Annexure 2, 48. Annexure 2, no, that is the police report. Annexure 2, page 48. It will be clear before lordship. On 4/4/2025, complainant Shahanur Ahmed, that means he is my son of Fakhruddin Ali so-and-so, that his father, that means me, my lord, that his father had lost his SBI bank checkbook account number 301320284434 on 10/4/2024 at Bartolova Bazaar. On 10/4/2024, I lost the checkbook, and the check in question was issued in Ten 12/2024. My complaint was registered, e-filing was registered, police report is done. This, my lord, by Kolegong Police Station GD number 22, dated 8/4/2025. And my complaint is on 10/4/2024, where I lost my checkbook containing various slips, my lord. And therefore, it cannot be brought under the Negotiable Instrument Act. It cannot be brought under the Negotiable Instrument Act, my lord. And they'll have to prove that the legally enforceable debt is liable to them. It is their plea. The plea shall have to be taken by them, not by me. So, my lord, I will place the judgments of the Honorable Division Bench of the Kerala High Court, as well as the recent judgment passed by the Manipur High Court, and also the Honorable Supreme Court, and is at 2 p.m. If your lordship kindly permits me that.
All right. Yes.
So I want, my lord, this case should be, well, the order that is the case that is pending in the court of the land CGM should be set aside and quashed, and the pair of mine should be allowed, my lord. That is my humble prayer before lordship. With lordship permission, I conclude my argument. And I may also be permitted to argue further if any point is raised by my outside.
Yes, yes.
So there are 6 cases.
Right now, I'm feeling like a judge of the British High Court. Please take me back to India.
My lord?
Yes.
Well, there are 6 cases. I'm appearing in 3. My friend is appearing in 1, and my learned friend is appearing in 2. So their basic case, which if your lordship has understood, is that they had 6 signed checks, which they lose. 6 people, different people from different places, get hold of these checks, and then somehow they go and file these 6 cases against him. That is his case. Now, your lordship will see, first I will address the case laws which my learned friend has regarding the division bench judgment of the Kerala High Court. That is basically, my lord, section 269 SS of the IT Act, that if there is any transaction beyond 20,000 rupees in cash, so that attracts the penalties of 269 SS. That has already been overruled by the Honorable Supreme Court, my lord. Sanjeev Tari's case, my lord, I've got the judgment, my lord. So that judgment has already been overruled. That judgment also takes care of the other aspect, but that your lordship already knows. It has been going on since Rangappa, that once the issuance of the check is admitted, the court is bound to raise the presumption of law that the checks were issued in discharge of a legally enforceable debt or liability. Earlier, it was the law was that the presumption was that it was in discharge of any enforceable debt or liability. Rangappa made it very clear that the presumption is of a legally enforceable debt or liability. So as long as the checks were issued by him, that those were his signature, the presumption has to be raised. Now, whatever be his contentions, even the contentions are, my lord, they have absolutely no value. But irrespective of that, whatever his case is, these are matters of trial, my lord. These issues cannot be examined in a 528 proceeding, my lord. Your lordship will see. First, your lordship will kindly come to. This is your lordship is taking up item 23, my lord. Page 48. Page 48, my lord, will kindly take up. This is apparently a police report, my lord. Till now, what we understood is if an FIR is lost, the police report is either a charge sheet or a final report. Now, this is some report which they have got. And what does it say, my lord? That on 4/4/2025, check was of, my lord, the lordship, this is a check of 10/12. So on 4/4/25, this complainant, that is the petitioner's son, he goes to the police station. This is a subject filing of FIR of mental harassment against the accused person so-and-so. His father had lost his SBI blank checkbook. So his father loses the blank checkbook with 6 signed signatures.
Bank
Checkbook, my lord. But then it has to be blank, otherwise we would not have entered his name. But it had to be signed by him. So he loses those. And reported under GD on dated 15/10/24, that 6 individuals, including the main accused Samsul Khondokar, have fraudulently used the lost checks to file case against his father. So on 15/10/24, he knows that these 6 individuals have lost the case against his father, whereas our cases have been filed in January.
So he preemptively knows there's some sort of an astrological knowledge he has that we are all 6 of us are going to go and file cases against him. He goes and lodges this police report. And what does this police report say? It does not say anything. In this report, investigation has been initiated with GD entry number so and so, and an inquiry is ongoing. What is the outcome of this inquiry, my lord? We do not know. Next, there's another e-complaint on the next page, at page 49.
He filed on 4/4/25.
4/4/25, I suppose this is the my lord second one, because there is a GD entry number 27 dated 5/10/24. 15/10.
The entry dated 15/10/24.
So on 15/10/24, he first approaches.
And NI Act case was lodged.
That is not in 1510, my lord.
Their document, my lord, I'm reading from. That is his claim, as per this report, that on 15/10/24, there is a GD entry saying that 6 individuals have got this check, and they, by misusing this check, they intend to file, not they intend, they have already filed cases against his father. That GD entry is, investigation is pending. Now on 4/4/25, he again files this complaint, and police gives whatever this report is, my lord. I do not know what is the sanctity of this report. This report is given. It does not disclose anything. It basically says that such a complaint has been made, which in itself is implausible, my lord. Then page 49.
The earliest he could have come to know is on receipt of notice demanding payment.
Yes, but notice was also not issued at that time, because the check was dated 10/12/24.
Yes.
And check was, legal notice was issued to him on 21/12/24. Lordship will find the legal notice at page 39.
21/12/24. Page
39. So he could not have known because there's no legal notice issued to him. So how does he know before the issuance of the legal notice that these persons, some random persons would find these checks, misuse it, and then file a case against him, my lord? And next, there is the next complaint is an e-complaint, printout of an e-complaint that your lordship will find at page
49.
49, my lord. Again, this is his complaint. These issues, my lord, cannot be agitated in a 528 proceeding, my lord. On this ground, when the presumptions of law are there, the check is, once the check is there, issuance of check is there, a presumption of law has to be raised by the trial court. This cannot be agitated in a 528 proceeding, because these are at the end of the day disputed facts, my lord. Unless and until there's an admitted fact, unless we admit that we have misused this check, this cannot be examined in a 528 proceeding, my lord. And your lordship will in fact see now in item 23, the copy which I have, this one page is missing, but your lordship will kindly see the next item, my lord, item 24, for a moment, my lord. (24) to kindly reverse. Just one page, my lord. Oh, we have to buy this one. Page 24, item 24, my lord, page 51. This is a reply, item 24, my lord, for criminal petition 580. And then page 51, annexer 7. The lordship will kindly see this is a reply to the legal notice which was sent to him, my lord, after the dishonor of the check.
Yes.
Your lordship will kindly see number 2, point number 2. That contents of para 2 is again not true, as my client has been residing with his son in Guwahati from so and so for medical reasons, and thus no money has been asked or taken by my client. In fact, my client has given money to your client through online transactions, which has been mentioned in that. So the factum of financial transactions existing between the petitioner and the respondent is admitted by the petitioner himself, my lord. So it is not some random person who has come and misused his check. This is a person with whom there is a financial transaction admittedly between them. Just relying on the judgments, my lord, to counter my learned friend's contentions. It will be question. Exactly question. Multiple plan GTS. Not hardly, I can out as it will. What will plan GTS? Lordship will kindly take my lord Rangappa. Rangappa, similar facts were pleaded, my lord. Your lordship will kindly see. Para starts from para 8, my lord. Para 8, my lord. Para 8, my lord. Same contention, my lord, will see. Following the developments, the complainant had filed a complaint under section 200 of CRPC against the accused for the offence punishable under section 138 of the NIA. The appellant accused had raised the defense that the check in question was a blank check bearing his signature, which had been lost, and it had come in the hands of the complainant, who had then tried to misuse it. The accuser's case was that there was no legally enforceable debt or liability between the parties, since he had not asked for a hand loan as alleged by the complainant. So same plea was also set up there, my lord, that the check had been lost, my lord. Now your lordship will kindly come to para 13 and 14, my lord. The High Court in its order noted that in the course of the trial proceedings, the accused has admitted that there also it is the case had gone for trial, my lord. The High Court in its order noted that in the course of the trial proceedings, the accused has admitted that the signature on the impugned check was indeed his own. Once this fact had been acknowledged, section 139 of the Act mandates a presumption that the check pertained to a legally enforceable debt or liability. This presumption is of rebuttal nature, and the onus is then on the accused to raise a probable defense. With regards to the present facts, the High Court found that a defense raised by the accused was not probable. In respect of the accused stand that he had lost a blank check bearing his signature, the High Court noted that in the instructions sent by the accused to the bank for stopping payment, there was a reference to check number so and so. This is in conflict with the complainant's version. The accused had given instructions for stopping payment in respect of the same. This part will perhaps not be relevant. The lordship will kindly come to para 27 directly, my lord. Para 27. Section 139 of the Section 139 of the Act is an example of a reverse honest clause that has been introduced in furtherance of the legislative object of improving the credibility of negotiable instruments. While Section 138 of the Act specifies a strong criminal remedy in relation to dishonor of checks, the rebuttable presumption under Section 139 is a device to prevent undue delay in the course of litigation. However, it must be remembered that the offense punishable by Section 138 can be better described as a regulatory offense, since the bouncing of a check is largely in the nature of a civil wrong, whose impact is usually confined to the private parties involved in commercial transactions. In the scenario, the test of proportionality should give construction and interpretation of reverse honest clauses, and the defendant accused cannot be expected to discharge an unduly high standard of proof. In absence of compelling justifications, reverse honest clauses usually impose an evidentiary burden and not a persuasive burden. Keeping this in view, it is a settled position that when an accused has to rebut the presumption under 139, the standard of proof is that of preponderance of probabilities. Next, my lord will kindly come to para 29. Coming back to the facts of the present case, we are in agreement with the High Court's view that the accused did not raise a probable defense. As noticed earlier, the defense of loss of a check was taken up belatedly, and the accused had mentioned a different date in the stop payment instructions to his bank. Furthermore, the instructions to stop payment had not even mentioned that the check had been lost. The perusal of the trial court record also shows that the accused appeared to be aware of the fact that the check was with the complainant. Furthermore, the very fact that the accused had failed to reply to the statutory notice under Section 138 leads to the inference that there was merit in the complainant's version. The fact that the accused is one more line on one paragraph. Yes. My lord will kindly one paragraph, my lord, para 26. This is the last important paragraph, my lord. In light of the extracts, we are in agreement with the respondent claimant that the presumption mandated by 139 of the Act does indeed include the existence of a legally enforceable debt or liability. To that extent, the impugn observations in Krishna Janardhan Bhatt may not be correct, because Janardhan Bhatt had said that this presumption was not for a legally enforceable debt or liability. So Rangappa, a three-judge bench overrules that finding and says that this presumption is for a legally enforceable debt. And when this presumption is there, unless and until they go and face the trial, the standard your lordship has seen is of preponderance of probability. So they'll have to probabilize a defense. But that probabilization of a defense has to be done in a trial, not in a 528 proceeding, my lord, on disputed facts. And the other judgment, my lord, which my learned friend had relied, that your lordship will kindly come to Sanjabis Tari, my lord. Rangappa takes care of the Manipur High Court judgment, my lord, which says that the complainant has to prove the legally enforceable debt or liability. Sanjabis Tari takes care of the other judgment. Para 19, my lord. Very clear, my lord.
Which one?
Para 19, my lord. Sanjabis Tari, my lord. Honorable Supreme Court of India. Para 19, your lordship has it. Para 19. Has it? Recently, the Kerala High Court in PC Hari has taken a view that a debt created by a cash transaction above rupees 20,000 in violation of the provisions of Section 269 SS of the Income Tax Act is not a legally enforceable debt unless there is a valid explanation for the same, meaning thereby that the presumption under Section 139 of the Act will not be attracted in cash transactions above rupees 20,000. Next page, para 20. However, this court is of the view that any breach of Section 269 SS of the IT Act is subject to a penalty only under Section 271D of the IT Act. Further, neither under Section 269 SS nor 271D of the IT Act state that any transaction in breach thereof will be illegal, invalid, or statutorily void. Therefore, any violation of Section 269 SS would not render the transaction unenforceable under Section 138 of the NI Act, or rebut the presumptions under Section 118 and 139 of the NI Act, because such a person, assuming him/her to be the payee holder in due course, is liable to be visited by a penalty only as prescribed. Consequently, the view that transactions above rupees 20,000 is illegal and void and therefore does not fall within the definition of legally enforceable debt cannot be countenanced. Accordingly, the conclusion of law in PC Hari is set aside. So that has already been taken care. In fact, the next paragraph is just for a moment, my lord. This court also takes judicial notice of the fact that some district courts and some high courts are not giving effect to the presumptions incorporated in Section 118 and 139 of the NI Act and are treating proceedings under the NI Act as another civil recovery proceedings and are directing the complainant to prove the antecedent debt or liability. This court is of the view that such an approach is not only prolonging the trial, but is also contrary to the mandate of the Parliament, namely that a drawer and the bank must honor the check. So this also takes care of the earlier contention, madam. One has to take up this presumption of law, madam. And one final judgment with lordship is perhaps aware, but Pradeep Kesarwani judgment, madam. Para, lordship will kindly come to para 20.
Yes.
Para 20, madam. Lordship has para 20.
Yes.
The following steps should ordinarily determine the veracity of a prayer for quashing raised by an accused by invoking the power vested in the High Court under Section 482 of the CRPC. Step 1, whether the material relied upon by the accused is sound, reasonable, and undubitable. That is, the material is of sterling and impeccable quality. Step 2, whether the material relied upon by the accused would rule out the assertions contained in the charges leveled against the accused. That is, the material is sufficient to reject and overrule the factual assertions contained in the complaint. That is that the material is such as would persuade a reasonable person to dismiss and condemn the factual basis of the accusations as false. Step 3, whether the material relied upon by the accused has not been refuted by the prosecution complainant and or the material is such that it cannot be justifiably refuted by the prosecution complainant. Step 4, whether proceeding with the trial would result in an abuse of the process of the court and would not serve the ends of justice. If the answer to all the steps is in the affirmative, judicial conscience of the High Court should persuade it to quash such criminal proceedings in exercise of the power vested in it under section 482 of CRPC. Because all of these have to be fulfilled, my lord. Here, my lord, the material which they have come up is one police report which says that they could contemplate before the complaint was filed that complaints would be filed. Of course, my lord, they could contemplate it because they had issued the check. So and they also knew that the check was going to be dishonored. So they could very well contemplate that this case will come up. But just because they have gone to the police and filed a complaint, this does not discharge their burden in a 528 proceeding, my lord. So, my lord, let them go to the trial court, place all of those things, let this police report, let the inquiry officer or whoever prepared it, let him also be examined. He will also come on record and say what he found. This cannot be decided in a 528 proceeding, in my humble submission, my lord.
I will
Law is not in their favor, my lord. Facts are not in their favor.
I will only take your lordship's 2 minutes valuable time. My friend has mentioned about me that I am the astrological knowledge, that he might have an astrological expert. And my friend has highlighted one very important matter. The complainant in the NI case has gotten criminal background. Many cases has been pending against him, my lord. I just want to draw your lordship's kind attention with your lordship's permission to page 64, annexure 5, and thereafter police report, annexure 6, page 66. Police report. I'm just reading out the relevant portion for lordship's kind convenience without taking your lordship's valuable time. On 26/11/2024, on 26/11/2024, I emphasize. Complainant, namely Shahnur Ahmed, that is my son, lodged an e-com at Sawa Setu portal stating that the accused person attacked him in public place and threatening him and planning to kill him and his family while he was standing with his friend at Bartolua Bazaar at a pawn shop.
What are we supposed to do it all this now? He may have criminal antecedents. What does it got to do it?
Yes, my lord. Again, my lords, I just want to draw your lordship's Supreme Court judgments in K and Bena versus Muniappan. It was held that the burden of proof that the check was not issued for any debt or liabilities on the accused. That is, I have discharged his burden, my lord. There shall be an enforceable legal debt. How come, my lord, as a person, I asked my friend that they just deposit me only 5 lakhs, you'll deposit me without any written paper. Can it be believable, my lord?
How have you discharged your burden that you can do only at the trial?
Can it be believable, my lord? 10 lakhs, that to 10 lakhs without any written document, without in cash, which is a violation of the Income Tax Act, specific, that is there in the specifically mentioned in Income Tax Act, section 2669 SS.
Believable? Crores are changing hands in cash. And you are asking whether 10
My lord,
10
I
lakh is
have come
believable.
before lordship. Your lordship has ample power under BNSS. So I leave it to your lordship, my lord.
Yes,
I
thank
leave it
you.
to your lordship, my lord. Highly obliged, my lord. Obliged, my lord.
Item number 26 similar is to the.
Similar, my lord, similar.
Items 23, 24, 25, 26.
26, 27, 28, my lord. Up to 28, 23 to 28, my lord. All are civil in nature, my lord.
CV.
Deeply obliged.
First item, then only to them.
Yes, Lordship, I filed one affidavit in opposition in this.
I have not received the copy. Yes, 29. I have not received the copy.
You will file.
Yeah. My lord, this matter may come up with criminal petition 866 of 25. 866. 866.
Learned
of
counsel for
25.
respondent pressed for some time to file additional affidavit. And hence place the matter again on so and so along with this. case.
We along with 866, criminal petition 866 of 25.
What's the blight?
May please, Your Lordship, for criminal petition for washing of the love affair, Lordship, the petitioner and the petition number 1 and the victim, Lordship, both are the amicably settled, Lordship. Have filed affidavit, Lordships.
You are appearing.
File affidavit. 66 years. Yeah, we say so.
Page 26, Lordship, the affidavit, Lordship. Right.
Is it joint petition?
No, Lordship.
No, Lord.
No.
Affidavit page, Lordship, 26, Lord.
Who lodged the FIR?
Siraz, Lordship.
Siraz,
Yes, Lordship. Father of the victim.
brother of the victim.
Father.
Father.
They were in love relation, Lordship. Due to misunderstanding, the lost their affair, Lordship. Got married and out of their wedlock, child was born, Lordship.
The victim should have filed.
I have a victim also executed an affidavit, Lordship, page 33.
Huh?
Page 33.
Started hearing it.
No, I deputy.
Three 76 is not there in the charge sheet.
No.
Only 366 A.
366.
511 447.
47.
All right, we'll dispose of this.
Lordship, I submit to judgment, Lordship.
Yes. CAB, huh? Yes, next.
Diploma.
Husband কিবা দিব সময় আছে।
Map.
I am for the informant, my lord.
Look, here, my lord, with all respect, my lord. Yes.
Yes.
Respect, my lord. Definitely, I'll read the FIR, my lord. Here, what has happened, my lord, amongst family members, my lord, ancestral, my lord, parents or, my lord, prior to that, my lord, they bought a plot of land, my lord, 1 kotha or something, my lord. There are cattle also, my lord. So that, my lord, the road by which they entered the plot of land, I have been told, my lord, there are, my lord, the haystacks, my lord, for cattle, my lord. So a dispute arose amongst ladies, my lord. They were arguing, whatever be it, my lord, and there's a mutual marpit, my lord. And thereafter, my lord, the deceased, my lord, elderly man, he was possibly having a heart condition, and that we have categorically stated in page 6, para 8, my lord. He fell down, and thereafter, in the mutual marpit, as has been told to me, my lord, he died subsequently. But my lord, with all respect, my lord, to be a case under section 103, my lord, there has to be lathis were used allegedly, FIR, and one specific role is attributed to one, my lord. May I come to the FIR now, my lord? That occurs at, my lord, page 11. With all respect, my lord, can I just read it, my lord? Most respectfully beg to state that there has been a dispute regarding a road with neighbors, but they are related, my lord. Rajesh Kumar Rai, Mukesh Rai, Kunnal Rai, Vishal Kumar, so and so, my lord, last 1 year. Tonight at around 9 p.m., aforesaid accused persons entered into quarrel over the issue of road and rebuked with filthy language, and a moment of the said quarrel, the aforementioned Mukesh Rai, specific allegation is against Mukesh Rai, my lord, not the rest, assaulted my elder sister-in-law, namely Sitola Devi, with a big bamboo stick and caused grievous injury on her head. And thereafter, Mukesh Rai, along with aforementioned accused person, chased my father-in-law. This gentleman unfortunately died. Father-in-law, namely Suresh Rai, and mercilessly assaulted him in the cowshed with an intention to kill him and cause injuries on his head and body. As a result of which, my father-in-law Suresh Rai unconsciously, apparent on while reading the FIR, my lord, unconsciously fall down. This is the language, my lord, at a place of occurrence. Although he was immediately taken to downtown hospital, but the attending doctor declared my father-in-law Suresh Rai dead. Now, my lord, to be a case of 10T, there are to be injuries ante-mortem, my lord. The deceased, my lord, in his post-mortem report, my lord, ante-mortem injuries are to be there. That need be the cause of death, my lord. Here, possibly no injuries, my lord, and he died because of a heart condition, my lord. And we have categorically said everything in our application, my lord. And this is our case, my lord. And out of the arrested persons, if the first allegation is true, then, my lord, petitioner number 1, even there are no injuries on the lady also, my lord, who was beaten up, because marpit was not to that extent, my lord. My lord, filthy words and little bit of fist and blows, my lord. Specific role is attributed to one petitioner, Mukesh Kumar Rai, my lord. The next is Kunta Rai. He is around 65 years of age, my lord. He cannot do marpit, my lord, mutual. And thereafter, one is a lady, Kajal Kumari, and the fourth is a lady, my lord. They are in jail, and they are in jail, my lord, it all from 51 days, my lord. Lordship, kindly ask my friend as to whether any injuries on the deceased, my lord. There has to be ante-mortem injuries, my lord.
There's a long-standing dispute between both the families, lordship, and on that day, quarrel took place. As far as statement of the witnesses, the petitioner has assaulted the lady and the deceased, lordship, with a bamboo stick. But going to the PM report, lordship, our opinion regarding cause of death is kept pending till receipt of report from
What are the injuries?
Injuries, sir, lordship, I have not found any injury. Wounds position and character not detected. Bruise position, size and are not detected. Any inquest report, lordship, I have gone to the inquest report also. Injuries, sir. Limbs none, right hand none. Only other information like wounds, bruises, marks of injuries, none. Whether limbs, body stiff. Any other injuries with left shoulder swollen seen. Lordship can consider his inquest and PM report also. PM the last part of the CD PM report and the inquest report here also. First one is the increase for data.
Yes, informant, anything to submit?
My lord's investigation is underway, and once see Rajesh, he is still absconding.
Absconding.
He has not been surrendered before the police, my lord. And if your lordship goes through the judgment order of the trial court, my lord, you'll find that number of sticks was given blown on this old person, my lord. As a result of which she has died there before being to the hospital. And there's no question of, my lord, heart attack and anything, my lord, which my learned friend has submitted. Because that order will clearly reflect, my lord. One or two blow is okay, my lord, but it is a multiple blow was given on that. They're about 65 years old.
No, order, which page?
Page your lordship will come.
What please go?
Order 30, page 35.
আমার
And this Rajesh is the main person, my lord, who instigate, and he is absconding. So let the Rajesh surrender, then your lordship will decide about the bill.
How can they make Rajesh surrender?
Let him surrender.
my lord, can I, of course, my lord, would peruse the session judge, আমি গাথা নাই নাকি
Session
আমি গেছি
Session says, yes, yes.
Oh, I'm sorry, my lord, we have come with clean ends, my lord, nothing to hide. মই দেখাই নাছিলো sound.
That's enough. That is my submission, your lordship will decide on that issue.
My lord, nothing on injuries, my lord, as regard the factual, my lord, as I have
Regarding
narrated.
what is contained in the FIR, that has been reflected in the order. but
Exactly, my lord.
In the conclusion part, it says case diary reveals investigation is at nascent stage, allegations with regard to murder. So from this order, we cannot say there are injuries or anything.
That will followed by the medical report.
Exactly, my lord. If the medical report indicates injuries,
All right, we'll examine the medical report.
my lord. Highly obliged.
MR.
Three application, my lord. Here the petitioner has been arrested, my lord, on 16th of October, my lord, and as of today, my lord, he is in custody, my lord, for 43 days, my lord.
What is the offense?
Offense is a case, my lord, 12, my lord. FIR is case 12, my lord.
Yes.
Dowry death, my lord, against the.
Dowry
my
death.
lord. Dowry death, my lord.
Receive.
Married, my lord. The lady was married with the petitioner, my lord, against her will, my lord. Had an affair with a boy of her locality, my lord. She committed suicide, my lord, by pouring petrol against her.
Can it
The day of incident, my lord, the petitioner was not at home, my lord.
Can it be after some time, my lord? Let's just go to that city properly. my lord.
Hey, please, your lordship. Lordship, CD was called for. I was on interim leave.
My lord, in this case, my lord, search is submitted, my lord.
But my bail may be made absolute.
To call for the TCR then.
This is an interim bail application, lordship.
Let him appear, my lord, and his interim may be extended till his appearance, my lord.
I have already appeared before the IO.
Now you have to appear before the court. The charge sheet has been submitted.
Isn't when notice is served to us, lordship. Till then, I may be protected.
All right, Hardware Counsel for the petitioner, learned additional PP submits that charge sheet has been submitted by CS number
28/2025, dated 31/10/2025.
as prayed for by learned counsel for the petitioner. Provided that the petitioner shall appear before the learned court below. And in the event of any application for bail being made, the same shall be considered as per law. Till that date, the interim order dated
5/9/2025.
shall remain in force. Petition stands disposed of accordingly.
Oblige, Your Lordship.
Item 34.
May I please? An application under section 482, Your Lordship. The last date, 10/9/2025, this honorable court granted interim protection to the accused petition. Accordingly, they appear before the concerned
Received.
station.
Received, and the case record is up to 20/08/2025. So may I pray for calling for the upward statement of the accused?
I have already
That statement is
cooperated
not
with
before
the
us, Lordship.
IO in connection with this case, Your Lordship.
Required the up-to-date CD. Couple placed between the parties, Lordship.
Except the section 353, Your Lordship, in connection with, all the sections are available in nature, Your Lordship.
But you are on interim protection.
Yes, Lordship.
The prayer of learned additional PP call for the updated CD. List again on so and so. Interim order passed earlier to continue till the next date.
Much obliged.
Lordship, 35, I think, arising out of same.
Same affair.
35 felony, right? Last year, we learned.
Different, I think, huh? Is it?
And 5 minutes, same PS, Lordship.
Same PS. Same order. Any interim is there?
Yes, Lordship, interim.
Same order.
Let me fix course. Sir.
36.
Your Lordship, my lord. Last occasion, my lord. Scan copy is directed to be produced. And this is the second application, bail application. Earlier bail application was rejected on consideration of the primary, my lord, early stage of the investigation. Of course, my lord, there is some long affair. There is some allegation against me, but basically paragraph 15 of the affair, it clearly discloses that the entire allegation is made on the basis of some suspicion. Charge sheet also they submitted. Charge sheet also doesn't specifically say anything. No any accused person who were already arrested and interrogated by police, my lord. They also didn't say anything except saying that on suspicion. From our, whether, my lord, on basis of suspicion, my prayer for bail may be, my lord, considered or not considered. And so far the second bail application is concerned, my lord, my second bail application is maintainable because of changed circumstances. Charge sheet was submitted and on health condition, my lord. Very long affair, my lord. And I will take your lordship just, my lord, para 15 of the affair.
Yes, have you gone through the TCF?
Yes, my lord. Now, my lord, this person, my lord, he was shown absconder in the search sheet, my lord. Now, my lord, materials that has been collected during investigation, my lord. I have just flagged, my lord. Lordship may kindly peruse the one. There is the orange color flag mark, my lord. Now, my lord, after submission of the search sheet, my lord, someone was issued. He has not appeared, my lord. Now, he has been declared, my lord, by order dated 4/3/38/2025, my lord. He has been declared as a proclaimed offender, my lord. Now, my lord, whether this anticipatory bail application is maintainable or not, my lord, this will look into, my lord. In this regard, my lord, I also rely on a decision of the Honorable Apex Court, my lord. 2014 to SCC 171, my lord.
2014,
2014 2 SCC 171. 2 SCC 2014 2 SCC 171. State of Madhya Pradesh versus Pradeep Sharma, madam.
what does it say?
It says, my lord, when accused is declared, my lord, or absconding and declared as a proclaimed offender, my lord, there is no question of granting anticipatory bail. When a person is against whom a warrant has been issued and is absconding or concealing himself in order to avoid execution of warrant and declared as a proclaimed offender in terms of section 82, my lord, earlier it was 82 of the CRPC, now it is 84, my lord.
So in the instant case, he has been declared as a proclaimed offender.
Proclaimed offender, my lord. PNA was issued, my lord, that has been served, my lord. That is why, my lord, order dated 38/2025 of the trial court, my lord, is important, my lord.
Then, my lord, in that situation, my lord, I will surrender, my lord. I have an option. Surrender and let, my lord, the court consider my prayer on the basis of materials.
If you surrender, you surrender. What are we supposed to do now?
My lord,
You're a proclaimed offender now.
right, my lord. But that instruction I didn't have, my lord.
So what do you want now?
Obviously, my lord, in view of the decision I have, since there was a decision of the Supreme Court, so my lord, in that situation, of course, court cannot consider my prayer for anticipatory bail. But in that eventuality, my lord, I will definitely appear, and some consideration maybe at law should kindly make some observation in view of paragraph 15 of the FIR, my lord.
But we can only say that your application for bail will be considered.
Yes,
as per law.
this much. The law should hands are tied, I understand, madam.
So and so. Learned counsel for the petitioner submits that in view of subsequent developments, petitioner surrendered before the learned court below and apply for bail. Considering the above, this application is disposed of with a observation that in the event of the petitioner's appearance before the learned court below and filing of any application for bail, the same shall be considered as per law. Petition stands disposed of accordingly.
I'm obliged.
Forty-three days, minute. After some time, and I have not been able to go to that.
All right, after something.
After some time, I will not be, take time.
Okay, then tomorrow.
Tomorrow.
Tomorrow, yes, tomorrow.
All right. Tomorrow.
Tomorrow.
Obliged.
Here, scan copy is called for. And last time, my friend said, charge sheet has been submitted. Scan copy, I come. Like that. Only statement of the victims may be in my lord.
Scan copy.
Our segment, my lord, 183 as well as 180, my lord, that may be perused. As per the trial court record, my lord, only cognizance has been taken, my lord.
Before filing charge sheet, I approach this noble court, my lord. That is why this noble court call for the scan copy.
What does it say actually?
My lord?
You have gone through?
Yes, my lord. But as per her 180, 183 and 180 statement, my lord, in both the statements, says that no offense has been committed by this accused person.
Third, counsel for the petitioner, additional PP. this is an application under so and so. The TCR as called for has been received. Upon perusal of the statements of the victim herself recorded before the police as well as the magistrate, it does not appear that any incriminating material has arisen as against the present petition. Considering the above, the prayer for pre-arrest bail is allowed, provided that in the event of his arrest, the petitioner so and so shall be released on bail of rupees 20,000 with one surety for like amount to the satisfaction of the arresting authority in connection with the aforesaid case.
Hello. And I will appear the trial court.
Yes, that is natural.
We have received the case that email.
What?
May please, your lordship, from the concern of the other side, the matter may be passed over for the day.
The side is here. All right, on the prayer of learned counsel for the petitioner, list the matter again on CD receipt be retained.
Sir, my lord, the indicate. Second ceremony का लोग कर दी. 5 तारीख के दिन.
Published.
May I please, your lordships. My lord, in terms of the order dated 6/11, my lord, we were appeared, my lord, and our statements were recorded, my lord.
So your lordships, that up to date CD was called for, so CD was not taken back from.
Right, up to date CD not available, hence is the matter again on so and so interim order passed earlier to continue till the date.
Problem.
Item 14.
Please, your lordship, pre-arrest bail application. FIR is at page 12. I am not named in the FIR, my lord. Because of some alternative medicine, my lord, I have resigned from that post at page 45 in 22. And on 29/10/25, my lord, I was provided the interim protocol. I'm not named in the FIR, my lord. Somebody else who was practicing, but as a registrar, I was there in that institute and I resigned in the year 2022, page 45. FIR is at page 12. And on that count only, your lordship has given me a protection.
Your name is Saha.
My name is M. Shanti Kumar Singh. I am not named there. My name is not there in the FIR. Page 12.
Who is US Sinha?
US Singh is somebody else, my lord, because I was a registrar of that institute. That is why, and I resigned in the year 2022. I am not a doctor, I am a doctorate, PhD holder. My resignation letter is at page 45.
Yes.
I have gone through the case diary and from the statement of the arrested accused persons and other accused witnesses, it has come to light that Northeast Council of Alternative Medicine certificate, which is fake, that was issued to him by the present petition. His complicity is very much
That was
clear.
during the time when I was the registrar.
Not a fit case for granting anticipatory bail at this moment.
And this institute stopped from the year, my lord, in 2000, maybe 2021 or something. During that time when the institute was there, I was the registrar. Now, after that it was closed, I resigned from the post. And now this UB Sinha, who is named accused, if he is practicing after the institute is closed, that is not my fault. During that time, the institute was there and it was closed subsequently.
The co-accused has already been arrested, Lordship.
And the judgment came, my lord, in Calcutta, this alternative medicine. In the FIR itself, it is in 23. page 13. When the Calcutta High Court in 23 has said, and I have resigned in 2022. And in page 14, as in 2000, my lord, in 2019, under the act, it was there. Registration was there. And the allegation is that somebody is practicing. That cannot be a ground for my fault, man.
But certificate is issued by the president.
But the statement is not said when the certificate was issued. That has to be said by the prosecution, not half-hearted. Full statement has to be given when it was issued, when it was under registration.
Go through the statement of the court.
Certificate must have been seized. Is it there in the CD?
He is in the CD.
One gentleman from your council is even practicing dentistry in Nagaon.
But if he's practicing,
Yeah.
my lord, there, my lord, I should not say before
Fake
the court.
councils.
There are many, my lord, like that in every profession going on.
Matter of serious concern that some qualified persons engage in such a.
Whether, my lord, after 22, I have issued the certificate or not.
You find it out when was the certificate issued?
Lordship, one more thing. To getting interim, he has not.
Because there was no direction. There is no direction as such. My lord, the direction is, again, my lord, the submissions are made without looking into the records. Please, if it is further provided, the petitioner shall cooperating with investigation as and when called for. If this is the direction when called for, how could my lord, my friends could suggest that?
Lordship, at least with the interim order, he can.
My lord, if not called for, why should I go?
Let us do one thing. It will be beneficial for you as well. Today we provide that you appear before the IO within a
My
period
lord,
of 7
I
days.
will appear.
Learned counsel for the petitioner and also learned additional PP. It's the CD as called for has been received. It stated that since the IO has not called the petitioner, he has not appeared before the IO. Hence, it is provided that the petitioner shall appear before the IO within a period of 7 days from today. This is the matter again after 2 weeks. 2 weeks they did. Interim order passed earlier shall continue till then. CD you have to send back?
Yes, Lordship.
Send back the CD for resubmission on the next date fixed. In
My lord, oblige.
Thanks.
Investigation is pending, Lordship.
So default bill may allow.
what was this? For mandatory period.
Whether
It's
the
over.
Charge is filed or not.
Huh? Okay.
The charge has been submitted or
Not submitted.
95 days behind the bar.
But learned counsel for the petitioner. It appears that the petitioner who was arrested in connection with Renzo case on, you were arrested on
Arrested on 24/8/2025.
25 has crossed the statutory period of detention of 90 days and is submitted by learned additional PP upon instructions received that the charge sheet is yet to be filed. Hence, the petitioner is entitled to default bail. Accordingly, it is directed that the petitioner shall be released on bail of rupees 50,000 with one surety of like amount to the satisfaction of the Dhaka Magistrate.
Kamrup Amingao.
Item 53.
May I please your lordship, my lord, at this stage, my lord, before opening with the file, my lord, this is regarding a motion stage, my lord, this is regarding asking for a further investigation of the case by the accused persons, my lord.
I have entered appearance on behalf of private respondent number 2. I have filed my wakalatnama. I have not been served the copy of the. I pray.
No, I have not served is the wrong word because.
On
we
the
have
last,
accepted.
it was listed day before. Mr. K. Singh has submitted that. He
No, why will you give notice until the court doesn't give you notice?
Then I
You are
will
not
submit on
fully
that.
entitled.
Then I will submit on that.
That's why I'm submitting, my lord, letter notice be issued, my lord. Then this matter will solve with the notice.
Mr. Swens, who
M.
is-
Moore.
has entered appearance for the respondent number 2. Copies of the petition be served upon him. Place the matter for
My lord, let a notice of motion be issued, my lord, and I will serve the copy to him. Then he will be. entitled.
notice of motion is not issued.
Not issued, my lord. That's why I'm saying. Today, first date, my lord. Oh, no, আজি first date. For motion movie.
Or let you write hard learned counsel for the petitioner. Hard learned. It is there.
My state is also there. We have served the copy, my lord. Because we
Additional
normally serve copy after notice is issued.
And
my lord.
also Mr. Moore, learned counsel, who had entered appearance for the respondent number 2 issue notice. Is of the petition be served upon the respondent number 2, learned counsel for the rest. Within 3 days
Within 3 days.
is the matter for admission on.
My lord. Admission hearing on after 4 weeks. That will do much.
In the meantime, we'll file our affidavit in opposition.
Item 41.
Lordship, in this case, the basic allegation against the petitioners is that, my lord, they are not named, my lord. It is alleged that while the informants were carrying some Erica nuts, my lord, from one place to another, my lord, then 2 vehicles stopped them on a road, my lord, near Bhalukmari area, my lord. Then 2 persons came out from the vehicle, my lord, and take their vehicle into a mill, my lord. They themselves identified themselves as police persons and take the vehicle to a mill, my lord, wherein they made some halla. Then these people fled away, my lord. My lord, this FIR was lodged on 26, my lord, and the allegation is attempt to commit dacoity, my lord. There is no ingredients of attempt to commit dacoity, my lord. Lordship is filed the FIR at page 10, my lord. And my lord, after about 2 months, my lord.
Yes, I did not receive today, my lord, already called for.
My lord, after about 2 months, my lord, my vehicle has been seized by the police, my lord.
This is the
So
first
my-
date. All right, we'll have it on the day.
5/12, my lord.
She did not receive list again on 5/12.
Go orders. Item
Yeah, please, your lordship. My lord, instruction was sought for whether my lord service is complete.
Some instruction was supposed to be received as
Yeah, my
per
lord.
last order.
For 4 consecutive order, my lord.
Huh?
For last 4 times, my lord, they are seeking adjournment for. My lord. The service of.
The proper person. Well, that is after some time, my lord.
Amicus curiae may be appointed otherwise, my lord.
After some time.
Of last
if-
Item 57.
So this was an issue.
None appears, list the matter after 2 weeks. Suspension of sentence maybe. All right, 4 weeks. maybe.
Item 58.
None appears, list after for the petitioner. List after.
Nine.
Sorry, my lord. Item 58, my lord. Not,
Yes.
I mean, my lord. This small issue, the earlier matter, last matter, my lord. 58, my lord.
Yes.
There's a condonation application, my lord, which I had filed. If my lord may take up IA number 1123, my lord.
How many? What is the delay?
My lord, there is a delay of 92 days, my lord.
92.
92 days, my lord.
What is the order?
The
Conviction.
order is dated 24/4/2024, passed by the Principal Judge Family Court 2, Kamrup at Guwahati, my lord. This is as regard to, my lord, and 125 application which they have preferred, my lord. The respondent herein, wife has preferred against me, and then
You have filed objection.
Lordship, I have filed an objection.
So what is your objection?
Lordship, the reason for delay here is not sufficient or neither is it bona fide, Lordship. For delay, Lordship, there must be sufficient cause and the reasons must be bona fide, Lordship. If Lordship looks, Lordship may have a look at the paragraph 6 of their petition, Lordship. They have stated that the petitioner begs to state that upon receiving the certified copy of the order dated 24/4/24, the petitioner could not immediately contact the present set of councils as the petitioner works outside Guwahati in Amingaon and comes home late at night. It is pertinent to mention herein that in the meantime, the father of the petitioner, who is a senior citizen, was suffering from various ailments, suddenly fell ill during that time, to which, being the only son, he had to be engaged in medical related works, Lordship. Now, Lordship, if Lordship will have a look at our objection, Lordship. In the meantime, they have said, and Lordship, I would like to point out one more thing in paragraph 9, Lordship, of their petition, Lordship. They have stated the petitioner begs to state that during the first week of October 2024, the father of the petitioner became stable, and thereafter the petitioner approached the present set of councils. Now, Lordship, as per them, till October they did not have the time to file the revision petition, the instant revision petition, Lordship. In the meantime, what they have done, Lordship, they have filed a divorce case, Lordship, before the Learned Family Court. And the date of the filing is 21/8/2024, Lordship. During the period which they have stated in their revision petition that they did not have the time, Lordship. They have approached their council, they have filed a divorce petition, Lordship, before the Learned Family Court. So where is the cause for delay? Where is the sufficient cause, Lordship? Not a single medical document has been annexed in the petition, Lordship. I have also brought some precedents, Lordship, regarding this denial of condonation, Lordship.
What is the order under challenge?
Interim maintenance order, Lordship.
Interim maintenance of 4,000.
Lordship, that is also in area, Lordship. They have not even paid the interim maintenance, Lordship.
It was fixed today, my lord. A substantial amount has been paid, my lord. Today.
No, Lordship, and in the family court today, Lordship, what the petitioner had said, the petitioner said that he had no knowledge about the terms regarding payment of the interim maintenance, while he had filed a revision petition in the High Court, Lordship. It clearly shows that he has approached this court not with clean hands, Lordship. This is a malicious intent to stay the revision, maintenance proceedings, Lordship.
What is your occupation?
My lord, I'm working in a private sector company, my lord. Tamilgaon. In fact, my lord, there is a big history to the entire case, my lord. I do not want to go into that.
Before we come to the end of the history,
my lord.
She has to survive.
Yes, my lord, certainly, my lord. There are serious allegations, my lord, against her. And this is a big, my lord, I'm sorry to say, but there's a big, my lord, connivance or racket that has been done and where I am a victim, my lord. She is earlier married, then she had divorced her, but she has concealed the entire fact and she has married me, my lord. In the marriage application which was filed before the registrar, she has stated that she is unmarried. And in fact, as to that regard, I filed a complaint case also. As I got to know about the entire fact within a period of one year, I have filed an application for, my lord, judicial separation. Subsequently, my lord, the judicial separation application was being withdrawn and now a divorce case has been filed. As soon as they came to know about the judicial separation, they came up before the learned Chief Judicial Magistrate and filed a case against me under domestic violence. There, they sought a compensation, claiming that their maintenance, they seek a maintenance of 35,000, but which was rejected. Subsequently, they went to the family court and filed an application under section 125. Where they have completely manipulated the facts and stated that she requires 15,000 only. The court, despite of having the knowledge that there is already a maintenance which has been rejected by the DV in the DV case, granted a 4,000, my lord, and the entire facts have been manipulated and filed that particular petition, my lord, in there before the family court, my lord, against which I have come before this honorable court. And the case which he is highlighting, as I have filed within the limitation, my lord, the thing is that only a transfer, their earlier case was withdrawn, the nomenclature was changed, and that case was being filed, my lord. And that too, at the 101 day of after passing of this particular order. And the rest of the cases, my lord, this case has been filed after 93 days delay, my lord. That they have not explained, that they have not sought. When their hand is in dirt, my lord, entire manipulation of facts, I have filed a complaint case also against them, that they have misleaded the sub-registrar, stating that they are unmarried. The Pandora's box will open, my lord, if I as this is only on section 5. Please let me complete, please. I have not completed. My lord, one thing, my lord, it is there that when section 5 application is being considered by my lord, by this honorable court, there has to be a liberal approach, my lord. And I have stated my father is a very old person, my lord. There are judicial recent precedents where it is stated that when there are facts which needs to be considered by a court, then the section 5 application needs to be considered liberally, my lord. And that is what in this case is, my lord, because they have manipulated facts and has got that particular order from the family court, my lord, by stating that they are not entitled to maintenance by stating that they are entitled to maintenance of 15,000. Whereas in the other court where they did not get an order, they have stated that their monthly maintenance they requires 35,000, my lord. Serious factual, my lord, contradictions are there on their part, my lord.
Lordship, regarding this, Lordship, you have completed?
Yes, please.
Lordship, regarding the facts that they have stated, Lordship, the family.
No, we will not go into that. We are only on the condonation of delay today.
Lordship. In the delay petition, Lordship, they have stated that their father was sick. And has any medical documents been annexed? And Lordship, regarding the order of the DV Act and the family court, Lordship, the family court is a grade A court. Let's say this is equivalent to a district court, Lordship. And trial court is a JMFC court, Lordship. It's much more junior to the district court, Lordship. Now they are saying that we have manipulated the facts. So if that is the case, Lordship, then the order of the family court should be binding on the JMFC court, Lordship. Then, Lordship, regarding this, they have stated that they have this. His father is a sick man. Lordship, any medical documents has been annexed. If his father was really sick, how did they approach the council and how did they file the divorce petition within that period? It's a clearly manipulated application, Lordship. And Lordship, unless sufficient ground and bona fide reasons have been given, Lordship, this petition cannot be
My father is
allowed,
a
Lordship.
80-year-old person, my lord.
Lordship, old
He
person and
tends-
being a sick person, they have sought the
He's-
ground because
he's-
he fell ill, Lordship.
My lord,
It's
I
in
can
their
also raise
petition.
voice, my lord.
It's in
If
their
raising voice
petition,
is the
Lordship.
question, I
Lord,
can
I
raise,
think
I
we
can
have heard
speak, my
enough.
lord.
Petition. Okay.
Obligement.
Yes, you have given insufficient address. Who is there? Nobody appearing. Service on respondent number, none appears for the petitioner. Service on respondent number 2 is not complete. Await service list again after 4 weeks. Interim order to continue till the next date.
Item 24.
May I please your lordships? The appellant has been convicted by section 6 of the POCSO Act.
In this case, my lord, the amicus curiae, my lord, he is in before the division bench, my lord. He is on.
What part wait for him again? We have heard once.
Yes, my lord. Our part is complete. The respondent sides are there. They have to verify the judgment of.
Okay, in view of non-availability of learned amicus curiae today, list the matter again on, give a date. Okay.
Planning that you.
Parted.
It is already
Parted. Obvious.
not 11. Go to.
Item 46.
Wait, please, lordship. Well, this appeal has been preferred against the judgment already dated, my lord. 29/9/2018, my lord. Passed by the Honorable Learned Additional Session Judge Vilasipara, my lord. In session case number 222 of 2011, convicting the petitioners, my lord, under section 324 to 24, 325, 34, my lord. Initially, charges has been filed against 6 of the person, and it was Ali Hussein, Rajiul Haq, and Fakhruddin, plus Monwara Bibi, Fatima Bibi, and Nur Jahan. Now, these 3, Nur Jahan, Fakhru Bibi, and Monwara Bibi, is acquitted from charge 323, 324, 325, 307, and 149 IPC. And we have been convicted for about 323 IPC for 500 rupees in default, 1 month. 324, 1 year rigorous imprisonment, a fine of 2,000 in default, 2 months. And 325 IPC rigorous imprisonment for 2 years, and 2 years, a fine of rupees 10,000 in default, 6 months. So, prosecution has examined as many as, my lord, 10 witnesses, including the IO, my lord. And the prosecution story, my lord, in nutshell is this. And the date of occurrence was 4/11/2008 at about 17 years back. So at that point of time, in the morning 6 a.m., this complainant, that is PW1, has gone for the nature call near the pond and the backyards of their residence. In that area, my lord, then the petitioners, sorry, this appellants, three appellants came and assaulted him with dao and all, causing injuries to PW1, my lord. And on the basis of which, my lord, the Bilasi case has been after the completion of the investigation, charges has been filed and they have been convicted. This 3% has been convicted and they are before the lordship. Now, so for the PWD1, my lord, is the alleged to be the eyewitness of the occurrence.
Remaining hearing.
So PW1, my lord, is a Nazrul Haq, my lord. He is a complainant, my lord, and also informant, also, my lord, an eyewitness to the occurrence, my lord. And, sorry, my lord, he is not, he is a brother-in-law of the victim, my lord. And PW2, my lord, is the Johurul Haq, my lord, is a victim, my lord. He is an injured person and also the brother-in-law of the complainant, my lord. So, 3, my lord, PW3, Imran Ali, eyewitness also, he claimed to be the eyewitness. He is an, my lord, independent witness, my lord. That is an important witness. He has to be looked into, my lord. Then, my lord, that Bibi, also relative of the complainant, she is also claimed to be an eyewitness. PW5, Abdul Mutlid, my lord, is an eyewitness. PW67, it's not legible, my lord. What my, it's a handwritten, my lord. It's very difficult to read also, my lord. That is why, my lord, I could not read properly because of the later how
That is it not reflected in the judgment?
Yes, it has been reflected. Now, may I read the judgment or?
Yes, you can read from the judgment itself.
My lord. Then I'll skip all these things, my lord. I have, why I have been shown, judgment is started at, from page 13 of my memo of appeal, my lord. So I skip, my lord, so the prosecution case is concerned. I don't have investigations, committals, charge, trial. Now point for determinations, argument, my lord. So I just start from argument from the page 15 onwards, my lord. These are the things, my lord. My lord, the question which has been framed, my lord, whether I should point of determination, whether the present accused person in prosecution in a common object 411 so and so, Rangapani under the Bilasipara PS was a member of unlawful assembly and committed rioting of the property of Jabrul Haq. Whether the present accused person in prosecution common intention on 4/11/2008 at about 6 a.m. at Rangapani under the Bilasipara PS voluntarily caused hurt by Ijjaton Bibi, whether the present accused person in prosecution common object on 4/11/2008 at about 6 a.m. at Rangapani under the Bilasipara PS voluntarily caused hurt to Tajima Begum by means of dangerous weapons as thou. Whether present accused person in prosecution of common object on 4/11/2008 at about 6 a.m. at the Rangapani under Bilasipara PS voluntarily caused grievous hurt to the Jabrul Haq by means of dao, lathi, khukri, etc. Whether the present accused person in prosecution in common object on 4/11/2008 at about 6 a.m. at Rangapani under the Bilasipara PS voluntarily caused grievous hurt to Jabrul Haq by means of dao, lathi, khukri, etc. with intention to knowledge that the death would cause Jabrul Hussain. So these are the, my lord, points for determination of the in the trial. Now, the learned additional public submitted their prosecution by adducing evidence of the injured person of the case, fairly able to establish the prosecution charge against the accused person beyond all reasonable doubt, and ocular evidence of the injured person is also corroborated by the medical evidence. And the prosecution beyond all reasonable doubt established the prosecution charge against the accused person. It has been argued by the learned defense counsel that the informant lost the Ejaha at a very belated stage when the incident was took place on 4/11/2000 on the next day at about 11:30 a.m. and therefore the prosecution case is fatal. He further submitted that before filing of Ejahar, the police did not get any information about the incident, and PW10 IO of the case in cross-stated they visited the place of occurrence on the next day of incident on 5/11/2008, but injured person were sent to the Satgram hospital on 4/11/2008, and they are sent to the hospital without GT number so-and-so and withholding GT number drawn adverse inference against the prosecution under section 114G of the Evidence Act, and clearly in lodging the FIR not been mentioned cast doubt in the prosecution case and cannot be convicted based on the delay lodging of the Ejahar without satisfactory explanations. He further submitted that the witnesses are not believable and evidence of PW 1, 2, and 4, 7 are inconsistent and made out statements, and their statement does not inspire confidence, and the court cannot be acted upon the convict of the accused person based on their evidence. He further submitted the presence of PW 1 at the place of occurrence is disputed by the evidence of PW 3 and other independent witness, and PW 1 stated that he rushed to the place of occurrence after PW 3 and other witnesses. Therefore, his evidence does not inspire the confidence. He submitted there is a difference in the ocular and the medical evidence on the injury, and there has no evidence coming out from the testimony of PWs against the accused person, Fatima Bibi, Munawara Bibi, and
Just one moment, Mr. Bora. We had some time being, small instruction was required. Let's take care of
yes,
it.
my lord.
Who is there with the instruction?
My lord.
42.
I've been informed that service is complete upon respondent.
Item 42.
Service is completed upon respondent number 2.
Service, upon instructions received, it is submitted that by learned additional public prosecutor that service is complete upon the respondent number 2. However, none appears to so and so is appointed as amicus to the respondent number 2.
Only give a short date, my lord.
This will be kept as a part of the report.
If be kept on the record. The matter again on.
Kindly give a short date, my lord. I cannot have my.
Amicus has been appointed, you have to serve copy.
Okay,
Then she has to come. Copy of the petitions which are served upon the amicus.
Hello.
Yes.
And PW1 stated that he rushed to the place of occurrence after PW3, and other witness or therefore his evidence does not. That is, I'm reading from page 16, line from the top, about 5-6 lines.
Yes.
PW3, and there is no evidence coming out from the testimonies of PWs against the accused person, Fatima Bibi, Munawara Bibi, and Noor Jahan, and evidence of the prosecution does not establish the prosecution charge against the accused beyond all reasonable doubt, and court cannot convict the accused. Contradictory statement of the material witnesses, therefore, the accused person is entitled to acquittal in support of the so-and-so decision, so-and-so, so-and-so, so-and-so. Now, prosecution evidence, what the learned trial court has stated, that PW1, Nazrul Haq, is the informant of the case. His evidence is that the incident took place on 4/11/2008 at about 5 a.m. The victim, Jabrul Haq, is the brother-in-law of Ijjatan Bibi, and his sister, accused person, reside in their same locality. He deposed on the day of incident, the early morning, at about 5 a.m. The brother-in-law of the Jabrul Haq went to the pond for fishing, and his brother-in-law, Jabrul, was accompanied by his wife and daughter. He deposed after some times that he heard hue and cry and said, and at the said place, he rushed to the place of occurrence and saw accused person was confining his brother-in-law, and accused person assaulted him on his body and head by sharp weapon and a stick. As a result, his brother-in-law receiving grievous injury on his head and body, and blood was oozing from the body of his brother-in-law. He deposed when his sister Ijjatan along with the daughter came forward to save Jabrul. Accused person also assaulted by them with sharp weapons, and they also sustained grievous injury on their bodies. He deposed many people gathered at the place of occurrence and could not resist the accused person, as the accused person possessed sharp weapons, and accused person ran away as the people gathered at the place of occurrence. Thereafter, he, along with the others, sent victim to the Saptagram hospital, and from there, victim was referred to the Tuguris hospital. And thereafter, he lost the Ejahar White Exhibit 1, wherein he puts his signature of White Exhibit number 11. He further deposed that he had witnessed the entire incident, and in the cross and injury caused by the accused person to the victim is serious in nature. In cross, he stated, though he did not write the Ejahar was explained to him. He stated at the time of incident, he was present at home. Well, this is very important. He, along with it, Iman Ali, Abdul Mutlib, Ibrahim Ali, and Sazmal, who were the neighbors of Jabrul Haq, went to the place of occurrence. Abdul Mutlib, Ibrahim, and went to the neighbors of went to the place of occurrence. Now, this Abdul Mutlib, your Lordship, kindly take note of that. He has been examined at PW5, my lord.
Yes.
Because it's a his evidence, his testimony is very important for deciding his case, my lord.
Abdul Mutlib.
Abdul Mutlib, my lord. Because he said that these are the persons who are witness are present at that point of time, and he was been examined as PW5 also, my lord. Now, went to the place of occurrence. After hearing he did not go the place of occurrence. Accused person did not assault his wife. There is a cross and his daughter. Accused person did not assault the wife of the Jabrul and his daughter. He did not state before the police that the accused person has assaulted on the head of the Jabrul. PW2, my lord, the Jabrul, that is the victim, my lord, and injured person, my lord. Jabrul Haq is one of the victim of the case. His evidence is that on the day of incident, in the morning hours, the accused Raijul Haq and Noor Hassan was illegally fishing in his pond, my lord. The question is regarding, my lord, fishing illegally at his pond, which is situated near to his house. Accordingly, he asked them not to fishing in the pond, but the accused person, Raijul Haq and Noor Hussain, did not listen to him and started quarreling with him. Thereafter, both the accused person called their family members, and all the accused person came along with the sharp weapons. But at that point of time, Rajiul Haq and Noor Hussain, they are fishing. They do not have any weapons on their hands. So when they have said that they have called their family members, they came. So, Rajiul Haq, that is appellant number 2, and Noor Hussain, my lord, they are not having this. He asked them not to fishing in the pond, but the accused person, Rajiul Haq and Noor Hussain, did not listen to him and started quarreling with him. Thereafter, both the accused person called their family members, and all the accused person came along with the sharp weapons. What is said that all the family members, my lord, sharp weapons and sticks, and assaulted his wife. His daughter, as well as him, he deposed all the accused person possessed sharp weapons like dagger, iron, rod, stick, etc. He deposed firstly the accused Ali Hussein assaulted his wife by stick and the appellant number 1. And thereafter, another accused also assaulted his wife. As a result of his wife fell down on the ground and she sustained serious injury on her elbow. He deposed accused person also assaulted his daughter by stick and sharp weapon on her shoulder as well as on her head, and for which his daughter still could not recover from the injuries. Thereafter, the accused person hit him brutally. Firstly, accused Ali Hussein hit him on the backside. As a result, he fell down his backside. Thereafter, all the accused person has assaulted on his head and head chest, and he sustained penetrating the injuries his forehead. He further deposed the accused person has broken his head, legs, sustained fracture injury on the body, and there was a profuse bleeding from the body as well as his wife and his daughter. He deposed the accused person left the place after assaulting them. Many people gathered after the incident. Village people came and people taken him to the hospital. He deposed that he was treated at Dhubri Hospital for more than 20 days, and his wife and daughter also treated at the Dhubri Civil Hospital. He deposed the incident. His brother-in-law lost the case before the Bilasipura PS and could not lodge the Ejaha. He was admitted in the hospital. He deposed. The police asked him about the incident. After few days of the treatment, and the accused Ali Hussein, Rajul Hussein and Nur Hussein threatened him not to give evidence. In cross, he stated that he could not recollect the day of incident, but incident occurred in the early morning at about 6 a.m. He stated he lost, it's very important, he stated that he lost civil cases against the accused person, and accused person also.
Yes, I have gone through that part. 4 criminal cases against him.
Yes,
he was acquitted.
They are the cases, counter cases against him regarding that pond and this thing, fisheries, that is the root cause of this incident, Now, if your logic will just whatever the your IO, but it's very important why I am saying that the statements which they have not stated before the police, for the first time they come to the court and stated all these things, Now, I will just see. I just read the PW fund, what this says.
PW?
5.
I have already read.
My lord.
He came there later on and he saw these 2 persons there actually.
Yes, my lord.
Incident he did not see.
Well, what has happened now as per the evidence of PW 1 and 2, so he was present at that point of time. So how this, because they are the logically see there are, for the evidence on record it found there are about 4 or 5 cases between themselves, cross cases. Now specifically said these they have, although there are as many as about many persons, specifically he named 1, 2, 3, and these are the person does not support their evidences. They are number 1. Why? They are independent witnesses. They are basically independent witnesses. They do not have a business with their family members.
So now, five did not support in fully support, but he said he saw.
My lord, the fully
Rajiul and Jabrul were present. He did not see the incident, but when he came back for the second time, he saw them there.
Saw them then, but there is a quarrel. But to what extent, my lord? Now 6 also, my lord, if your lordship kindly see.
At least after he did not, after coming back for returning, he heard that fresh dispute again started.
My lord,
he said that he had witnessed Imran at the place of occurrence near the pond. Cannot say with whom the subsequent dispute started, and he witnessed Rizal.
Now just another witness.
So he did not see the incident.
But before lordship, that is a major contradiction. What PW, those who are informant, what he says that he is the present, Now what he says, now kindly see that PW3, my lord. This is also very important. There's a short, my lord. I just read this evidence of PW3, my lord. I know the complainant and an accused person. The alleged incident occurred about 4 or 5 years ago. On the date of occurrence, the incident was early morning. I went to my paddy field, my lord. It's very important. After arriving the paddy field, I saw a scuffle between accused Rajul and victim Jamrul. Rajul and victim, they are brothers. As a result of such incident, Jamrul Ali fell down, sustained head injury, my lord. Now what he says, he is also eyewitness. Now what he says, as a result of which such incident, Jamrul fell down and sustained head injury, my lord, is very important. Thereafter, I and another boy, Aminul, brought the victim to the house and took him to the hospital, my lord. He is the person who he saw the entire incident. He said that there's a quarrel and because of that, he fell down and got an injury on the head. And he's an independent witness. I know, I saw blood oozing from the injured portion of the victim. I know this much only. Now,
But during cross-examination, you managed to extract from him that he saw you assaulting the victim. Although it was not there in the chief.
Yes, my lord. That is a state of affairs, my lord. When we went to the pedophilia, I saw accused Rajul, who was assaulting Jamrul, victim Jamrul, fell down on the ground in front of me. The head of the victim fell down on the hard substances. Only thing is this, so the injury, head injury is concerned, my lord. It is not because of the inflicted injury by me. It was because of I fell down in the hard substances on the rock, my lord, resulting which there's an injury, my lord. I and Aminul took the victim to the house. Thereafter, no any incident took place. Both the accused Rajul and Jamrul were fighting and quarreling each other. My lord, there's only one person, that is Rajul and Jamirul. Rajul and Jamirul means Rajul is appellant number 2, my lord. Other than not, only so far the PW3 is concerned, my lord, he said that there is a quarrel between Rajul and so and so. And because of what he got injury on that by. Now, if your lordship kindly see, I'll just skip all these things, my lord, and come to straightway IO, my lord. IO, my lord, that is at IO. It's I just.
Right in.
IO, my lord, that is PW10, my lord. Just I'll say, I was posted at Bilasipura. I was posted at Bilasipura PS District Jury as an ASI. On the day, OC Bilasipura Police Station received an Azarha filed by one Nazrul Haq and registered a case, White Bilasipura PS case number so-and-so, and endorsed to me for investigation. Accordingly, I took charge of the instant case and visited the place of occurrence. At the place of occurrence, I recorded the statement of the witnesses and also prepared a sketch map of the place of occurrence. Exhibit 10 is the sketch map and Exhibit 10.1 is my signature. The injured person had already sent to Sapatgram Hospital for treatment by the police of Sapatgram. Later on, I sent the injured person to the Dhubri Civil Hospital. Accordingly, I collected the medical report of the accused person. I also seized 2 bamboo sticks. Well, kindly see what is sticks? 2 bamboo sticks from the place of occurrence as shown by the informant exhibit. Informant has showed these are the weapons they have been used. That is the bamboo sticks. These are my on being transferred. I had handed over the case diary to the OC so-and-so. Cross-examination. Occurrence took place on 4/11/2008 and I visited the place of occurrence on the next day, that is on 5/11/2008. The injured person was sent to the Sapatgram Hospital. I have not made any GD entry for sending the victim hospital. I did not make any requisition for sending the injured person to the Dhubri Hospital. The complainant did not explain me the delay of lodging the Ejahat. I found Nazrul Motin, Ibrahim and Safiquddin at the place of occurrence. I also found bamboo stick at the place of occurrence and I seized them. I said the said bamboo sticks are not available today in the court. So this bamboo sticks also not been exhibited. Quote, the place of occurrence is an open area. There was a railway line near the place of occurrence. There was also a small pond of Jabrul on the western side of the place of occurrence. The accused person and the victim are relatives. No any sharp weapons were found at the place of occurrence. On 5/11/2008, I recorded the statement of the witnesses Ibrahim Ali, Abdul Motib, and Sofiquddin. And on, my lord, your lordship kindly say, 27/11, after, my lord, almost 1.5 months, he recorded the statement of Jabrul, that is the victim. Sorry, that is the victim, Jabrul. And Istadan Beva and Arjuna Begum at their house. I do not record the statement of the witnesses at the hospital. PW1, my lord, is very important. Nazrul did not state before me during my investigation that his wife and daughter were present at the place of occurrence. That is number one. He also did not state before me during my investigation that he had hue and cry at the place of occurrence and he rushed to the place. Number two, PW2 Jahirul Haq did not state before me during my investigation that he was under treatment for 1 month. He also did not state before me the accused person was illegally fishing in the pond, and when he resisted, the accused person, they assaulted him, my lord. The victim, my lord, did not state before the police, my lord. And PW4, Izzatan Bibi did not state before me during my investigation that she saw Ali Hussain, Rajul Hussain were present at the place of occurrence. So also say that PW4 also didn't say about that. She also did not state before that the Ali Hussain assaulted her husband with a dagger with accused person gathered. PW Secretary Tankim Begum did not also state it before me, Fakhruddin assault so and so. It is not a fact. I have not investigated the case properly, so and so, so and so. So the course of investigation, my lord, the PWs has not stated before the IO that who has inflicted, my lord. Now it's a duty of the prosecutions, my lord, to prove its case beyond all reasonable doubts, my lord. Now, as per the prosecution story, there are as many as about 4, 5, 6 persons they have been searched. Now, in the aid of 149, the unlawful assemblies, my lord. Now, first of all, it has to be proved that we are in an unlawful assembly first. Now, that 149, the trial court has discarded so far the 149 is concerned, my lord. Now, so far the injury is concerned, my lord, there are as many as injury is concerned, my lord. Now, so for the PW2, who is at injured, his statement has been recorded 1.5 months after, my lord. If he claims that I was in hospital, my lord, even if after the recovery, even he should tell to the IO that these are the things. And he didn't stay about it. IO has stated clearly. So my respectful submission, my lord, these are absolutely contradictions. That evidence of PWs, basically PW 3-5 doesn't support, my lord, of the and the incident of 8, my lord, 2008, my lord. And now we are in 17 years, my lord. So I not, my lord, because your lordship has gone through the evidence on records, my lord. So these are the things which I, lordship, in support of my argument, my lord, it's a case of a clear acquittal. Even though, my lord, if your lordship find, well, there 325, 23, we have been convicted, my lord. 18 years, my lord, has gone, my lord. And by, suppose if your lordship founds that they are having injury reports so far the medical is concerned, but maybe, my lord, after 18 years, my lord, they may have benefit of, my lord, Provision of Offenders Act also, my lord. These are the two, my lord, my grounds of, my lord, length of, my lord, my argument, my lord. Subject to what my learned friend has, because they are from the
Yes, prosecution.
complainant side, my lord, they have appeared, my lord, and
The learned trial court has rightly convicted persons under section 5, 320. Sentence him to rigorous imprisonment for in default 6 months. Section 325. Thereafter, Lordship, on 324, he was convicted for 1 year. Rigorous imprisonment. Fine of rupees 2,000. In default, 10,000. Yes, sir. And under section 323, pay for fine of rupees 5,000. In order to bring home the guilt of the accused persons. 325 and 324, Lordship. 10 witnesses. This, including the medical officer, as well as PW1, who happens to be the informant, the brother-in-law of the victim. PW2, who is one of the main victim, Lordship. He has categorically stated that all persons has assaulted him when they have entered illegally for fishing in his pond. And thereafter, some altercation took place between the parties, and all the accused persons had assaulted the victim. Lethal weapons, Lordship. Sustained multiple injuries. Next, Lordship, I have come to PW3. Also one of the independent witnesses who saw the occurrence and also seen that Rajul and victim Jabrul was at a fight, and Rajaul has inflicted assault upon the. Thereafter, Lordship, PW4, who happens to be the another injured persons and the wife of PW2. She also saw Ali Hussein Rajaul Haq assaulting her husband, Jabrul, and Nur Hussein and Fakhruddin also assaulted her husband. Hit on his back, and his teeth, hands, and legs also got injured. And and the injuries were inflicted upon the victim, sharp weapon as well as blunt weapon. Thereafter, Lordship, PW5, who happens to be another neighbor, who has also seen the altercations with try to settle the dispute among the parties. That means presence of the accused petitioners is very much proved by the independent witness, who happens to be PW5, Lordship. Thereafter, Lordship, PW6, he has declared as hostile witness, and PW7 is another injured person, happens to be the daughter of PW2. He has also sustained injuries, and she has also witnessed the occurrence. All the accused persons has inflicted, assaulted her father, her mother, and herself, Lordship. And thereafter, Lordship, PW8 is the IO. PW9, who is one of the sterling witness, his statement is corroborated.
PW9 is medical.
PW9, the doctor. His statement is very much categorically, he stated that victim PW2, PW7 and PW.
Sustained both simple as well as grievous injuries. Mandible was broken.
Yes, Lordship, and his teeth is also broken. His legs, hands, in several parts, he has sustained injuries. Since the prosecution is able to prove the entire case beyond all reasonable doubts, rightly convicted, the trial court has rightly convicted the violence under section 3.
You're appearing for whom?
For informant, my lord.
Yes.
Lordship, in this case, important fact to be noted is that the incident took place on 4th November 2008, my lord, and statements of the witnesses had been recorded after 7 years, my lord. My lord, in this gap of in this huge gap, some minor inconsistencies in statements bound to occur, my lord. That is my first point, my lord. And secondly, my lord, in such a case, my lord, the statements of the victims who are eyewitnesses are most important, my lord. No other person can explain the situation other than the victim, my lord. And there is not any inconsistency between the statements of the 3 victims, my lord. And their statements are also corroborated by the opinion of the medical officer, my lord. Therefore, my lord, in my view, the guilt of the 3 accused persons are established beyond reasonable doubt, my lord. This is my humble submission before your
My lord, short reply to what my learned friend has said. Has relied on, my lord, medical evidences, and my learned friend has said regarding delay in recording the evidences, my lord.
Yes.
That cannot be a ground, my lord. We are not having a civil case on preponderance of probability, my lord. We are on a criminal cases where we have it is the burden with the prosecution to prove it beyond all reasonable doubts. Now here is a case, my lord, if your lordship kindly see, PW7 has been declared, he claimed to be the eyewitness, and he was declared hostile. Even he's making a hostile also. Number 1, I'm sorry, 6. 6 is Saifuddin Ali, my lord. Now what Saifuddin Ali has been declared hostile, my lord, because he has not supported the prosecution case, my lord, and prosecution has also, my lord, examined him also. So there is nothing against us. Your lordship kindly see that what PW6 says, Saifuddin is deposed that he knows informant, injured, accused person. He deposed the incident took place at about 5-6 years back. In the morning hours at about 6:30 a.m., he heard that the altercation between the place between the Zabrul Haq and accused person with regard to fishing, and Zabrul sustained injury. Now this is what his evidence is concerned, my lord. Now in the cross also said by prosecutions, so and so, defense so and so is another the cross by the prosecutions, my lord, he is declared hostile by the prosecution cross. He stated that he was present at the place of occurrence at the time of incident. He denied the day of incident hue and cry took places near the pond. An accused person armed with lathi so and so assaulted Zabrul and injured him. Hearing here and Q, wife of the injured Zabrul, come to the place of occurrence. An accused person also assaulted her and his witnesses. The whole in the cross by the defense, he stated that Zabrul Haq, the accused person Ali Hussain Rajul Haq, are own brothers, and there was a land dispute between them. He further said that he saw Imran Ali at the place of occurrence. Nothing more than that, my lord. One has said that it is the Rajul, and there is a quarrel between Rajul, my lord, not the others. And he fell down on the hard substances of this, as a result of which he sustained injury on the head, my lord. And second is what? The injured has been admitted in the hospital. In the hospital, while you sending, he has not sent on the police requisition. It has been sent on by own, his treatment. After he recovered 1.5 months, my lord, his statement has recorded. While statement has been recorded, he should tell the IO that so and so. And absolutely, his evidence and IO's this statement before the IO is absolutely contradictory, my lord. This is a contradiction, major contradiction. The question of minor and major doesn't arise at all, my lord. My respectful submission, my lord. When there is a contradictions, my lord, so there should not be any doubts, my lord. So whenever you say that the victim is what? I am the victim, and suppose if you are treated, my lord, you got cured, my lord. Once you get a cured, will you forget whatever the incident is concerned? My lord? Definitely not. He has to say that these are happened, these are the person, 1, 2, 3, 4. Fine. You may left out one, that's a different thing. But you have to be specific that because they are the brothers, their own brothers, my lord. And there are, if you had it been, my lord, a different person, you do not know about their names, and by face you know him, that's a different thing. And it is between their family members also only. So that is my respectful submission, my lord. The prosecution has failed, my lord, and miserably failed, my lord, to prove its case beyond all reasonable doubts. So it's a clear case of acquittal, my lord. And moreover, my lord, they have already, during the course of investigation, they were put behind the bars also. And they have been released by that also, your lordship has to be taken into consideration, my lord, in deciding the appeal, my lord. I'm obliged, my lord.
As testimony as a prosecution witness on the material point that occurrence has taken place. Specific allegation is well proved by the victims as well as the independent witness, which is also supported by the medical evidence. So to that regard, also the defense has failed to demolish the testimonies of the PW, the material point that the assaulted the victim's lordship. This is my humble.
What my submission to my reply to that, that has to be, even the evidence of witness is sufficient. One witness is sufficient. It is credible, my lord, trustworthy, my lord, and reliable. You do not want, my lord, quantity of witness, my lord, quality of witness, even if it is one, my lord. Now one doesn't, even one also doesn't support, my lord. These are the, my lord, kindly see why I am telling you, these are between the family members. They are those who are independent, 3, 5, 6, they are the independent, my lord. They said different story, my lord. There cannot be a two different story, my lord. So if there is a two different story, my lord, one goes in favor of so-and-so, one goes in favor of the accused. Definitely it goes in favor of me being a criminal case, my lord. So that's my response. Much obliged, my lord.
CP.
মই কালি বিয়া খাই আছো, তাইক কলো ফাইলটো লৈ